Hello and welcome to JIGL question paper analysis. So I'm Soumya, a chartered accountant and a company secretary. So today we will be discussing about the JIGL December 2023 paper. So this is only for today's session is for new syllabus. Okay, so before taking up the paper or analyzing the question paper, so few things or few tips I wanted to give you with respect to exam. See, when it comes to writing the answers, first thing what you have to keep in mind is you should write the answer to the point. Okay, it's not like this is a professional exam, so it's not like if you write a lengthy answer, you will get more marks. Okay, so it's not that you have to answer to the point. That is, in the sense, you have to understand the question properly, and according to that, whatever they have asked, that you have to understand. Accordingly, you have to answer. So it is, you don't go by length of the answer. So it can be for 5 marks, but only it has, one paragraph of answer. So that could be fine. So please, don't worry about the length of the answer. Just you concentrate on the question, what they have asked, and accordingly, you have to write the answer. So that is one thing. Second, coming to the type of question. So there will be, two types of question. So one is with respect to uh, direct question. So direct question means like, they'll ask in today's paper also, whatever we are discussing, that is December 2023. If you see one question is related to validity of the customs. Okay, custom, in order to call it as a valid custom, what are the things that are to be present? What are the essential ingredients? So this is a direct question. Okay, so you can easily answer. If you know the points, just you write the points and you will answer. So that is one thing, direct question, so that you understand the question and direct answer you can write. Another type of question is application based question. Application, in the sense, you have to understand the concept really well, and you have to apply that concept. That is, they have given you a situation, you have to understand the concept, you have to understand the question, you have to apply whatever you have learned, that concept, to the given situation, and you have to answer. That is where students feel it little difficult. But if you understand the concept well, I mean, you're strong at the concept, and you can crack the question, that is what exactly they are asking. If you can understand that, you can answer very well. Because direct question, it is, you can easily answer. Direct question, there is no problem, everybody can understand, each and every student can understand and write. But if students get confused, or maybe they feel that they're stuck only when it comes to situation based question. And nowadays, if you see, in the recent attempts, institute is concentrating more on these kind of situation or application based question. So now we will try to analyze the, when we are solving the paper, we will try to analyze each and every question. See, rather than seeing the answer, because answer, once you know the question, what information they want, what kind of answer they want, easily you can answer. So that is secondary. But the first thing what you have to understand is you have to crack the question. You should know what is that they are asking. Because if you see, 90% of the students, definitely you would have prepared well, and you know the concept, you know the answer. But question, understanding the question is where it's very, very important. So that is why first we will mainly concentrate on understanding these kind of situation or application based question, and we will go take it forward. So first we will understand the question, we will try to understand what is that they want to know, what is that they are asking. Okay, then we will go forward. So before that, as I told you, two tips you have to keep in mind. That is, don't go by length of the answer. Okay, don't think if I write more, I'll get more marks. So it is exactly what they have asked, you have to write. Okay, the person who is evaluating your answer should not feel that you are beating around the bush. It's just that whatever they have asked, you understood the question really well, you understood the concept really well, and you are giving the answer. So this is how it has to be. So with this little introduction, we will start with the analysis of the paper. So first we will take up, this is new syllabus, December 2023 paper. So I'll just share the screen. I'll share the guideline answers. We will try to understand the question, and then we'll try to see the answers also. So if you see here, I think you can see the screen which I'm sharing. Yeah. So here it says, we know that this maximum marks is 100 and you have 3 hours time and number of question is 6. You have to answer all the question. See, internally you have the choice. So question number 4 and question number 6, you have choice. But when it comes to main question, that is like this question number 1. 1 you have to answer, 2 you have to answer. So internally you will have choice. So all the 6 questions you have to answer. So we will go to the first question. Okay. See what happens, they will give a lot of information in the question. So you should not, by seeing the question itself or seeing the length of the question itself, you should not panic. You should try to understand the question, what they want, or what information what they want, which concept they are asking, and what you have to answer. Okay, so we will see this. First, I will read out the paragraph and then I will tell you how to concentrate or on which point you have to concentrate in order to find your answer or write your answer. See, the principal of a convent school, Agartala's sister Mary Fernandez. Okay, she is the principal. She has filed a case against 2 persons. Okay, that is Ali Khetan and John. See, she has filed, that is principal of a school, has filed a case against 2 people. This is the first information they have given. What is that she is alleging? What is her complaint? It is that they had made defamatory remarks. So she wants to file a defamation case. That means defamation is what? Defaming her, insulting. Okay, so she is filing that. She is alleging that there is a, defamation. So that they had made defamatory remarks in the complaint, which they had submitted to the Deputy Commissioner Agartala. That means they have given a complaint. Okay, first these Ali and John, they have given a complaint against this school principal. Okay, and in that they have mentioned many things, so which is completely which is wrong, and she now wants to file a case against them, telling that case is not valid. Only they just wanted to defame us, our school, so that is why they have filed the case. This is what she wanted to prove. So what is this all about? First thing what you have to understand, these 2 people, that is Ali and John, have already filed a case and that did not stand. So as it did not stand, and now our school principal, she wants to take an action against them, that she wants to prove it is just a pure defamation. Okay, so this is the situation. So they have given maybe one paragraph of information, but the whole paragraph, what you have to concentrate, that principal now is filing a defamation case against 2 people. Why? Because those 2 people had earlier, they had filed a case against the school principal. So what is that case is all about? We will see. Okay, that the building of school is unsafe and it may bring about any disaster upon the students of the school, and that it's a money minting institution, and the indiscipline, they say students are not good, they are indisciplined, and it is kind of it's kind of creating problem, around, it's creating a problem for the people, who are living around, or so all these things, like, that's just a money minting institution. They don't want to teach discipline to the students, good behavior to the students. So, and we have tried to complain, to the principal, but she did not listen to us. These things they have mentioned in their complaint. So this is first complaint. Okay, there are 2 complaints. First complaint is made against the school principal by 2 people, Ali and John. Okay, that did not stand. So now principal in turn, she is filing a case against these 2 people, telling it was complete defamation. Okay. So that it appears that the school has become meeting place for both sexes, and the principal's sister Mary Fernandez is turning a deaf ear towards the character of the students. So that if these are not checked in time, then they may become a great problem for the city. So this is the earlier complaint, the first complaint, and now this is what is defamation. This principal is trying to take an action against these 2 people. Next, so this was a complaint, and later in an inquiry before the subdivisional magistrate, the allegations of the accused were found to be false. So it was false. It was found to be false, and that case was it was dismissed. So the complaint or case was dismissed. So it did not stand. So now principal is taking action, is trying to take action against these two people. So consequently, so all these things happened no earlier. So now sister Mary Fernandez approaches the police station to file a criminal defamation case. So one criminal defamation case she is filing against the accused people, that is uh, John and Ali. So next, police registered a case of defamation, a bailable offense against Ali Ketan and John Augustine. So police has filed a case, they have accepted the case, and it is a bailable offense, who later files an application in court asking for anticipatory bail. So these two people, they are trying to get an anticipatory bail. Okay. So it's registered as a, so our principal has filed a case against these two people telling it is defamation. And what happened? These two people, it's a bailable offense, but these two people want to take an anticipatory bail. So they are trying to take an anticipatory bail for that, so that they'll not be arrested. Next, see, Sister Mary Fernandez, that is the school principal, she has filed a case. Okay, she has, Mary Fernandez, she has filed a case against these two people. One is criminal case and one is civil case. Okay, criminal case is she wants to take an action against them, and civil cases she needs a compensation. Okay, so Sister Mary Fernandez also files a civil suit seeking compensation for defamation. So in the reference of above, so this is the story. Okay, the story is just two cases. So one is filed by two people against the principal, that is they are telling the school is not good, it's a money making institution, and they have not they're not teaching the students good behavior and all those things. So this is causing problem, and if it is not taken care of, then it will cause a big problem to the city. All these things is the first case that was completely dismissed. Now the school, that is the principal, is taking action against these two people, and she has filed two cases. One is criminal and one is civil. Criminal is defamation, and action should be taken against them for that reason, and civil case is because she needs a compensation. And in the meantime, these people have, and that's these two people have applied for, they want to take an anticipatory bail, but the case is bailable offense. Okay, this is the case, or this is the story. So only these 4 points, the whole question I am summarizing, only 4 points you have to remember. First point is two cases are filed. Okay, the first case was two people filed a case against the school. And next one is school is filing a case against these two people. So these two people, when they filed the case, it was completely dismissed. So now the school wants to file a defamation case. Plus, along with that, they want a compensation. They have filed a civil case also, they filed a criminal case also. And these two people, it's a bailable offense. The complaint is registered, but they want to take an anticipatory bail. So these are the only 4 points you need to remember, or you need to understand. So with this information, we will try to answer the questions which are given below. First one, they are just, see, this is kind of a direct question only. Okay, even though the situation is given, all these things are there, just they are asking what is criminal defamation in Indian law. So just you have to write what is criminal defamation. So you will see this. See, only this much you have to write. So according to 499 of IBC, whoever by words, either spoken or intended to be read, or by signs, or these things, these words you have to be careful. So these things, like visible, visible representation, signs. So these words, others, explanation and all, you can write it on your own. That is not a problem. But these words, like either words, by words, either spoken or intended to be read, signs or visible representation, these words, you have to write it as it is. Okay, when you write it as it is, then, there is chance of scoring high good marks, rather than writing in your own words. So these words, concentrate. So whoever makes or publishes any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will cause harm, the reputation of such person is said, except in the cases hereinafter accepted, to defame that person. So except those exceptions are there, no defamation. So apart from that, all other things where you're using the words written or spoken, or any visible representation or signs, through that, if you're trying to cause harm to any person's image, then it is called as defamation. Okay, image or reputation. So that is called as defamation. This is what is defamation. Now, explanation. There are four explanations. So you can you can write it. So if you remember what is explanation one, what is explanation two, write properly. Okay, give like this only subheading. You give explanation one, explanation two. By chance, if you are confused, see you don't know between two and one, you are confused. It's okay. Don't write explanation one, explanation two. Just give a subheading as explanation. Write all the 4 points. If you remember, very good. Okay, well and good. You write that only. Explanation one, what it says. Explanation two, what it says. Okay. In case, you forget, or maybe, you're a little confused. You know what is one, two, three, four, everything, four explanations also. But with the numbers, you are confused. Maybe between one and two, or three and four, two and three, you are confused. Then it's okay. Just write, give a subheading as explanation. As far as possible, avoid giving any kind of wrong information. Okay. So just write subheading as explanation and write the points. That's all. Don't mention explanation one says this. That is wrong. Correct? No. If you write explanation one as a subheading and then give explanation two, sentence, that becomes wrong. That is wrong. Don't do that. So just write explanation and write all the 4 points. In your own words, you can write. It's not that exactly you have to reproduce or whatever is given in the book. In your own words, what explanation one says, what two says, what three says, what four says. At least the summary, if you know, write a subheading as explanation and give the points. That's it. Your first answer is done. Okay, so these are the 4 explanation. So first thing is it may amount to defamation to if you impute anything to a deceased person. If the imputation, so the tax talks about the deceased person, the person who is already dead. If the imputation would harm the reputation of that person, and if living and is intended to be hurtful to the feelings of his family or other near relatives, then it may, when it is defamation, they are trying to give more information regarding defamation. So it may amount to, next explanation is it may amount to defamation. It may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. Then explanation three is an imputation in the form of an alternative or expressed ironically. So all these are, different explanation, which is already, available. Maybe you would have, because the exams are fast approaching, you would have studied this. So the thing is, what to write is important. So content, what you have to write and how to understand the question is important, rather than the, going through the answer. Because these things, direct question, this is what is criminal defamation? It's a direct question. Everybody can answer. But the thing is, how to understand the question and what are the things which are important, which you have to pick up, to answer. So these things you have to keep in mind. So explanation four, again, no imputation is said to harm a person's reputation unless it directly or indirectly, in the estimation of others, lowers the intellectual character or moral of that person, or lower the character of that person in respect of his caste or calling, or lowers the credit of that person, or causes it to be believed that the body of that person in a loathsome state, or in a state generally considered as disgraceful. So in any manner, see, they have given one, two, three, okay, specifically. In general, explanation four says, see, anything you do, no, which lowers the image of a person in, in front of others. So it can be related to his caste or his profession or whatever, his character, whatever. Or maybe it's just that, puts that person in a loathsome state. That means everybody start to develop hatredness. Oh, I don't like this person. So that if you create, that kind of image in someone's mind, that then it is called as defamation. Okay, so I say something about a person which creates a bad image, in the public, that, till then they were, respecting him. But the moment I made that statement or I gave that information, immediately people started to hate him. So his image has come down. So this is called as defamation. That explanation is in general. So these four explanation, you can just first you are telling what is criminal defamation, and then you are trying to give the explanation. So as I told you, if you don't remember the number, you can write just explanation as a subheading and give the points. Okay, so next one. So just for, see, 4 marks, these 4 explanation and the definition, what is criminal defamation, if you write, you will get marks. Then comes to the second one. See, this also, if you observe, somewhat, looks like, what do you call, kind of direct question only, easy, you can understand easily, because if you know the concept, you can answer. So what it says is, the application for anticipatory bail by accused Ali and John is maintainable. So is that see, they have given no anticipatory bail, they have applied. They want to take an anticipatory bail. Is it correct? Because this is a bailable offense. Case has been registered, it is a bailable offense. Now you have to tell, they are expecting an anticipatory bail, but will that stand? Is it correct? Is it maintainable? The answer we will see. See, this is also, again, it's for 4 marks. Just these 2 paragraphs, if you write, you will get marks. Okay, so we will see what is this. See, section 438 of CRPC provides that the provision relating to anticipatory bail. See, again, coming to sections. If you remember the section, well and good. If you don't remember, it can be case law or if it is, section, exact section, if you cannot quote, if you don't remember, at least write as per the provisions of CRPC, as per the provisions of CPC, IPC, whatever it's, okay, at least that much, like that you start the answer. But never ever quote a wrong case law or never write a wrong section. See, assume you are confused, like whether it is 438 or 439, don't take a chance. If you really 100% please go ahead, write it. Okay, definitely it will create a good impression in the mind of the person who is evaluating your answer. Definitely it helps. So I'm not telling you should not write the section. Please write if you know 100%. If you're 100% sure, please go ahead and write it. Otherwise, just, you can write as per the provisions of whichever act or code, whatever it is. Okay. So it provides that, so 438 talks about anticipatory bail. So according to 438 of CRPC, if you see, when any person has a reason to believe that, they are trying to explain what is anticipatory bail, correct? No. See, if our question is what they are asking, whether in this case, anticipatory bail is maintainable or not. So for that, you are telling first what is anticipatory bail. That means, so if I am anticipating that for this case, somebody will arrest me. So then I can get an anticipatory bail before I'm arrested, before the police takes that step, I will take a bail. So I'm anticipating, it's not actual, I am anticipating an arrest and I am taking an anticipatory bail for that. To avoid that, I'm taking an anticipatory bail. So you are first telling what is anticipatory bail in the first paragraph. Okay, so he may apply to the High Court or Session Court for a direct direction under this section, and the court may, if it thinks fit, say just because you have applied, it will not be approved or given. So if the court thinks fit, they will grant it. So they can direct that in the event of such arrest, he shall be released on bail. So defamation being a bailable offense. So now our case, what happened? The defamation, it's a bailable offense. So now, and anticipatory bail under CRPC can be given only to a person who apprehends the arrest for a non-bailable offense. So first, what you are telling, you are trying to explain what is anticipatory bail. And next, what you are telling, see, anticipatory bail is available only for a person who apprehends arrest for a non-bailable offense. So anticipatory bail is not available for a bailable offense, because after arrest, you can anyway get a bail. Correct. No, so anticipatory bail is only for non-bailable. And in our case, for John and Ali, this anticipatory bail application is not maintainable. They will not get it. So hence, in the given situation, application of Ali and John is non-maintainable. So that's it. Then next question. So whether the complaint filed by Ali and John against Sister Mary Fernandez leads to libel defamation or slander defamation. Explain. See, this is also easy. So what is libel? What is slander? First, you have to tell that. So in libel, the defamatory statement is representation made in some permanent and visible form, such as written words, caricatures, cinema film, effigy, statue. So, so what it says, in libel means libel is you are defaming a person using some permanent form. That means, see, in case of if I'm using some, paper, temporary form, that I just, it's not recorded. See, now this is live on YouTube, correct? No, it will be saved. You will have this video whenever you want, you can come and watch. So in this video, if I try to defame some person, that becomes libel because it is a permanent form. It will be there for the long time. People can again go and watch it, they can refer it. So that is libel. But a slander means what? It is some temporary form. This is just I will no recording, no upload on the Facebook or YouTube, nothing. I will just have a gathering. I will call you people and I will say something. I'll give some information about a person. Okay, that is you listen to me. You remember it for 2 or 3 days or maximum a week, and then you forget it. That is slander. Okay, so slander is made with spoken words or some transitory form, whether it can be visible, audible, whatever, but it is of temporary in nature. Okay, so there is no recording, no this one. It is not available for your future reference. So that is slander. So in the given situation, complaint made can lead to libel defamation of Sister Mary Fernandez. So this is a libel. So first you have to explain what is libel and what is slander. And in our case, whether it is a libel or slander. So they are asking. So this is libel only because they have filed a case. It is in permanent form. So it is libel. Next, see, this is one thing. They have given an alternative answer also because if you have understood the concept very well, then you have another way of answering this. So we will see what they're telling. See, 8 exceptions provided under 499. See, there is an exception which is provided. So it provides that it is not defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over that person with respect to the subject matter of accusation. See, in one of the defamation exception, what it says is, see, in good faith. See, I felt this school is just minting money and it is not giving or it's not teaching a good behavior to the students. So, any person who is having lawful authority, that is what the case I am filing. See, I'm not conducting a what do you call a get together, or I'm not having a meeting wherein I'm trying to tell all bad things about the school or principal. I'm not doing that. No, lawful authority. We are having lawful authority. I'm going to a court. I'm filing a case. So that is fine. So that is lawful authority they are having. I tried to tell the principal. She did not listen to me. I just went to the person who is having lawful authority and I'm trying to give a complaint. So that is fine. That is not a defamation only. So like that, they are trying to give an alternative answer. But I would suggest like you explain, because directly they have asked no, libel and slander. So better you explain that and say in this case it is a libel. But what institute says is, if you consider it as an exception and you write an alternative answer, that will also be considered as a correct answer. Okay, so that you can go through. They have given an illustration. Okay, next we will go to the question 4, that is D. That is, what is the jurisdiction of the court to try civil suit where wrong done to the person? Okay, so next, this is the jurisdiction of the court. This is related to civil court. Okay, this is also kind of a direct question only. Correct? No, so just they are asking about civil court jurisdiction when it comes to where wrong done to the person. So if you see section 19 of CPC, it talks about the provision relating to suit for compensation for wrong done to a person or movables. Okay, so we will see what it says. So where a suit is for compensation for wrong done to the person or to a movable property, if the wrong was done within the local limits of the jurisdiction of the one court and the defendant resides or carries on the business or personally works for gain in another court, within the local jurisdiction of another court, then the suit may be instituted at the option of plaintiff in either of the said courts. See, that is actually where the wrong has happened. Okay, that jurisdiction court, and the defendant is residing or defendant is carrying on his profession or business in another jurisdiction of the court. That is like, for example, there are 2 cities. Okay, in one city, actually the wrong has happened. Okay, I have suffered a loss. In another city, actually the defendant resides or he is carrying on his business or profession. So now I should decide where I have to file a case. Both the courts are having jurisdiction where wrong actually has happened or where the defendant resides or carries on his business. So this is up to the plaintiff. So whichever is convenient to me, that I can select. So that is just that much. If you write your one, the answer is done. Okay, next question is about publication of defamatory words. Okay, what is publication of defamatory words? That is E. So we will see this. So publication of defamatory words, this is also direct, no? So it's easy. Just, you have to answer what is publication of defamatory words. It means making known of the defamatory matter after it has been written to some person or other person to whom it is written. So that is ambit of publish is very wide. So what is publish is wide. So publication of defamatory matter means it is communicated to some person other than the person about whom it is addressed. That is, I am insulting Mr. A. Okay. It's not that I'm going and telling Mr. A. Instead of telling A, I'm telling all other people like B, C, D, E, everybody I'm telling. This is what is publishing. So publishing means it can be printing and publishing, or it can be, just I am instead of that person actually whom I am defaming, instead of that person, I'm telling it to everybody. I'm trying to defame him in front of everybody. So everything comes within the ambit of the word publish. So in essence, that means in the summary, in essence, a publication is communication of the statement to any third party, not the claimant or the defendant. That means, but actually not the parties. Apart from that, to every other person, if I go and tell something bad about a person, which reduces his image or reputation, that is called as publication of defamatory words. Okay, so these three things you have to keep in mind. First thing is, it is making known defamatory matter after it has been written to some other person of whom it is written. Okay, then ambit of publish is very wide. That you keep in mind. And then this sentence. In essence, publication is the communication of the statement to any third party that is not a claimant or the defendant. Okay, next 1F. We'll go to 1F. So the question, I'll just read it out for you. It says, it asks, like, what is the time period of limitation for compensation in defamation? So you are asking compensation, no? She is asking, that is, principal is asking for compensation. What is the time limit? So that is what you have to write. So this is for 3 marks. So time period of limitation for compensation in defamation are as under. For first one, for if it is a libel, okay, for compensation libel, it's 1 year from when the libel is published. So when it is published, the defamatory matter is published. No, from that day you have 1 year time. In case of slander, that is 1 year when the words are spoken or if the words are not actionable in themselves, when the special damage complaint of results. So 1 year you have to take in, even in slander or in libel, both you have to take 1 year. So it is just the way you are writing the sentence, that in 1 year of when libel is published, but in slander you have to write both 1 year when the words are spoken, or if the words are not actionable in themselves. See, directly did not have, actually directly whatever I told, no, did not it did not create any such kind of information, or those words were not so such that they did create, impact on the people. It was not that directly did not have anything, I did not create any kind of defamatory matter by words. But if you see, indirectly it has created a bad image about you in the society. So then whenever that has occurred, no, so on that day you have to calculate 1 year. So 1 year when the words are spoken or written, words are spoken. That means when I gave a speech directly, I'm talking about, I'm talking about you, or maybe I'm giving such an information, or I'm using such sentences which directly defame you in front of the public. Okay, from that day you have 1 year time. Or directly I did not defame you, but indirectly it has caused some special damage. Like, for example, I will tell you, see, I'll just tell, see, you're very good at your work. Whatever you accept, no, if you take any orders, exactly you cater to the demands of the people. I mean, your customers. Then later, last sentence I'll tell, in these 10 years, maybe assume you have 10 years of experience in this field. In 10 years of your here, this in a person's profession, never he or she has delivered the products on time. That means what? Directly, I did not defame you. Directly, I did not tell anything, like which has insulted you or which has created a bad image in the public. Directly, I did not do anything. I told you are really very good at your profession. Your service is awesome. All these things I've told. Last sentence, what I told, you never give the orders or you will never deliver the orders on time. This has created a special damage, or this has created a special kind of a bad impact on the people. So from this day onwards you can take 1 year's time. That's what they're telling when the special damage complaint of results. So like that, indirectly, maybe I'll not tell never, you've delivered, but I'll tell, see, you usually, you take extra time. You always ask for extra time. It is better if you deliver on time. Something like this indirectly I'll tell, so that it is directly, you can't tell it as defamation also, but indirectly it is causing you a damage. So from that day, when people call you and tell, see, she has told, in her speech, she told everything good about your work, your service, your products, everything. But the thing is, lastly, she mentioned that you are not delivering the products on time. What is this? Now it's an insult. I mean, it is causing not an insult, but it causes special damage to you. So from that day onwards, you have to calculate 1 year time. I mean, the limitation period. Okay, so that is about first question. Sorry, I did not get you. In question paper, what is that you're asking? Can you please be clear on that? Yeah. So now we will go to the second question. So that is, the modern Indian law as administered in courts is derived from various sources, and these sources fall under two heads, that is primary and secondary source. Correct, no? So judicial precedents are considered as primary source of Indian laws. So we have sources of law, the first chapter itself. So where you have, sources have been divided into primary and secondary. And when it comes to judicial precedents, they are primary source. So that much we know. So next question is, what is judicial precedents? What do you mean by judicial precedents? So first three sentences are first two sentences, if you see, they are giving you some information. So modern Indian law is administered in courts, derived from various sources, and the sources of law see, actually those things are not that important. So we know that primary and secondary, we only know, correct? No. So next, what they are telling, judicial precedents are considered as primary source. Yes, that also we know. So the last part, what they are asking is, what do you mean by judicial precedent? That is what is important. So you have to answer 2A, you have to answer what is, first you have to give the answer, what is judicial precedent. Properly, you have to explain what is judicial precedent. Then, okay, so we have analyzed that part. That is in A, the first part we have analyzed. Next, read the following statement. So they have given two statements. You have to read and explain what kind of precedent it is. So they have given you two situations or two statements. You have to read and understand what kind of precedent is it. So there are many types of precedents. No, persuasive precedent, authoritative precedent, all these things are there. So original precedent. So in that, if you see this sentence, what kind of precedent is that you have to tell? So we will see this. Vishaka guidelines were stipulated by the Supreme Court of India in Vishaka and others versus State of Rajasthan in 1997 regarding the prevention of sexual harassment at workplace. Okay, they have given one case law, and it was about prevention of sexual harassment at workplace. Then they acted as precedent for many cases. That means what? This case only has acted as precedent for many cases. That means in future, whatever sexual harassment at workplace, those kind of cases come up, no, they referred this case only. So 1997, Rajasthan, state of Rajasthan, that is Vishaka and others versus state of Rajasthan, this case has become precedent for other cases in future. So what is this case then? So they acted as precedent for many cases during 97 to 2013 until Protection of Women from Sexual Harassment Act 2013 was enacted. So up to 2013, from 1997, because in 2013 we have this act which has come into existence. Till then, this case was a precedent. That means everybody were following this case. That means this case, that is Visakha and others versus State of Rajasthan. What kind of case is this? What kind of precedent is this? You have to answer. So we will see this. See, judicial precedent means what? It is a guidance or authority. So, of past decisions of the courts or for future cases. So, it is like a guideline for future cases. That is a judicial precedent. Whatever has occurred in the past acts as a guidance for the future cases. So, only such decisions which lay down some new rule or principle are called. See, each and every case will not become a judicial precedent. We say, no, some landmark judgments or new, which applies a new principle altogether, which, applies a new rule. So then which lay down a new rule or a principle, those things become a judicial precedent. So that is about judicial precedent. So now the situation, if you see, in the given situation, it is the original precedent because others started following this, correct? No. So it has become a precedent for the later subsequent cases, means this is the original precedent. So in the given situation, okay, see, do you get case laws in the question paper? Yes. In maybe out of 6 questions, maybe at least 2 or 3 questions, they will, mention the case laws. For that, you main case laws you should be knowing. But the thing is, mostly, even though you get case laws name, no, by seeing the other information in the question, you will be able to answer. So you need not worry that, what if I don't know this case law? Don't worry, because even if they give the case law, just like that, directly they can't ask, okay, write this case law. Only one line question, write this case law, like that they can't ask. After that, they will give some information. Based on that, if you really know the concept well, you can answer. So don't worry much about, important case laws, definitely you should know. But the thing is, you need not worry too much about the case laws only. Even if they give the other information, what they give, no, on the basis of that, you can definitely answer. Okay, so this is Vishaka's case only. If you see, it has become a original precedent because others started following it. So that is the answer. It's a original precedent because it has applied a new rule or a law regarding the prevention of sexual harassment at workplace. Okay, that is one thing. Next, we will go to the second situation or a statement. So the decision of one high court may not be binding on the other high court. Correct? No. We know that high court means they're all of same level only. So one, because see, Karnataka High Court has given some decision, means Tamil Nadu High Court need not follow that because they belong to same level. Okay, so one decision will not be binding. If you want, you can take help of that, another High Court decision. But as a High Court, you need not follow what another High Court has followed. So, but the decision can give a principle which may be helpful for other high court. So, high court may or may not follow the principles of the decision. So, one high court may or may not follow the decision of another high court. So, it's not compulsory or binding on them. So, what kind of precedent is this? It is a persuasive precedent. So, if you want, if you feel it is helpful, you can take that, essence. Otherwise, you can leave it. No problem. You can completely give a altogether different decision. So it's a persuasive precedent, and it is one in which the judges are not obliged to follow, but which they take into consideration and to which they will attach a great weight as it seems to them to deserve. That means if the judge of one high court feels that, this is important, yes, this case law reference I will take and then I'll give the judgment, they can do it. So I'm talking about 2 high courts, okay, 2 different high courts. So if Karnataka High Court has given some decision, some judgment, which the same case come up in Tamil Nadu. Okay, there the Tamil Nadu High Court judge, if he feels that yes, I will take help or a reference of this, Karnataka High Court judgment, they can take it. Otherwise, they can leave it. So 100%, there is no obligation for a high court to follow the decision of another high court. So this is called as what? Persuasive precedent. So that is A. So we are done with 2A. Now we will go to 2B. So what it says, Ramji Lal, the donor, made 2 gifts to his nephew. So this is, uncle and nephew. So this is 2 things you need to remember. First sentence is that Ramji Lal is a donor and he has made 2 gifts to his nephew. So uncle is giving some gifts to nephew. Dhoni. Gajendra is Dhoni Ramji Lal as donor. The first gift was his one immovable property situated in Delhi. Okay, one gift is immovable property. The second gift were three movable properties. Okay, two gifts he is giving. So two gifts means two gifts is bifurcation is one is movable and one is immovable. One property located at Delhi is an immovable property, and other three movable properties are gifted to Gajendra. Then he did not get the gift deed registered for movable and immovable. Both the properties, whatever movable or immovable, both he did not register. But before that only, uncle died. So now tell whether Gajendra, that is the nephew, whether he is entitled to both the gifts or not. So now we have to see the Registration Act, and according to that, we have to explain. So in this, what you have to understand, there are two things which has been, so this is related to gift. Donor and donee is there. Okay, this is related to gift. There are two types of gifts. That is, one is immovable and one is movable. Movable, three numbers, one immovable property located at Delhi. But this person, he decided to gift, and he is he is gifting also. But the thing is, before registration, all this other process is complete, but before this registration, he died. So now what happens to the gift? So we will see the answer. So now you should be knowing about the gift also, and you should be knowing about immovable property, and you should be knowing about what will happen to movable property. Okay, so we will see the answer. So first, instruments of first you see, you only properly bifurcate. Okay, first you talk about immovable property, or first you talk about gift. So three bifurcations you have to do. One is you are talking about gift, then you are talking about immovable, and then you are talking about movable property. Or you talk about immovable and then you tell what happens in gift, and then you talk about movable. So, but you have to properly bifurcate the answer. Don't mix it up. Okay, you're talking about immobile also, you're talking about gift also, you're talking about movable also. Everything in one paragraph only, if you include or if you write, then it creates a kind of confusion, or maybe the person who is evaluating, he may feel that you don't know the answer, so you are mixing everything. So don't do that. Properly bifurcate and write. So first we will see instruments of gift of immobile property fall. So we know that it needs a compulsory. When it comes to immobile property, definitely the registration is compulsory. That we know from Registration Act. So then, if a donor dies before registration, then the document may be presented for registration after his death. See, if he has done all the other procedures and only registration is pending and he dies, then after death also you can get it registered and it is 100% valid. Okay, so it may be presented for registration after his death, and if registered, it will have the same effect as registration in his lifetime. So on registration, the gift deed operates from the date of execution. So not from the date of registration, it will operate from the date of execution. So this sentence is important. Okay, you have to concentrate on that. So first, so we are talking about what? Immovable property needs a compulsory registration as per Registration Act. And then we are talking about gift. So when it is a gift, you have, and it is an immovable property, you have to get it registered. But before that, if a donor dies, yes, done execution of the document, everything he has done, only the registration part was pending, and before that he dies. That's fine. So you can get it registered after his death also, and the date will be counted as the date from the date of execution will be counted, and not from the date of registration. So this is about immovable property and gift we have written. Next. So here, if you remember this, case law name, you can give a reference. It's good. So it was held by Privy Council in Kalyan Sundaram versus Karupa. See, all this CIR 1927, these things, you leave it. At least the name, you have to write it properly. Okay, in Kalyan Sundaram versus Karupa case, that much at least you write. That while registration is necessary solemnity for enforcement of a gift of immobile property, it does not suspend the gift until registration actually takes place. So they are by giving, see, first paragraph, they have told what happens in an gifting of immobile property, and then they've explained also, see, even if the donor dies, if he has executed the documents, you can get it registered after his death also. So for this, you have to give a reference, no explanation you have to give. So when the case law is available, try to give a reference to it. Okay, in Kalyana Sundaram versus Karupa case, it was decided like this. Okay, Privy Council has told this, like that. Okay, you can tell. So the gift will take place, or the gift will be valid even if it is even if it is registered after the death of the person. If it is executed while he was during his lifetime, it is executed. So, but it is registered after that, no problem. So this was decided in Kalyan Sundaram versus Karupa. So, and it does not suspend the gift until the registration actually takes place, when the instrument of gift has been handed over by the donor to donee. Okay, the instrument of gift is given by donor to donee, execution, everything is completed. Only that registration part is pending. And you can register it later after the death of the donor. Also, you can register. So that is not a problem, but you have to get it registered. So, and if it is presented by the person having necessary interest within the prescribed period, the registrar must register it. So, neither the death or no express revocation by the donor is a ground for refusing the registration, provided other conditions are complied with. That means all the conditions, whatever is required, like properly it is executed, and the donor has given the documents to donee, means registration is complete within the prescribed period. You go to the registrar, you get it registered, so no problem with that. So after that, if he tells I'll not give you, or you return the documents, or maybe if he dies, all these things will not matter at all. Other conditions should be fulfilled. So, however, again, if you take movable property, there is no compulsory registration required, so no problem only. So, in the given situation, the gift deed of 3 movable gifts to Gajendra are fully enforceable, because registration of a movable property is optional. So, that is not compulsory. So, it's just optional. So, if you want, you can get it registered. Otherwise, fine. So, now the donor has died. It's okay. So, no problem. Registration is optional. But however, again, immovable property is compulsorily registrable. Hence, Gajendra needs to apply for registration of gift deed of immovable property. And if it is registered by the registrar, then it will be operative. It will become operative from the date of execution and not from the date of registration. From the day when it was executed, from that day only it will take into effect, or it will be considered. Okay, next we will go to 2C. That is the second, the third question in second main question. So I'll just read the question. A, the son of B, okay, A, son of B, sold a property of B, presuming that he will get the property of B after the death of B. Is it valid? Explain. See, here what it says is, see, there is a father and son. Son thinks that anyway, I am the higher. Okay, I will only get, no, yeah, I'll on inheritance. I will only get after the death of the father. Anyway, I'll only get the property. So now only he thinks that I am the owner, and he will sell the property. Father is still alive. He thinks that anyway, tomorrow I am only going to get the property. So now only I will sell it. Is it valid? So we will see the answer. See, actually, it's just if you apply common sense only, you will know that it is not valid. Correct. Now, when the owner is alive, just because he is going to, get the property after the death of the father, he cannot tell, I will now only today only I will sell. So he can't become the owner today itself. So that it's not valid. So how they have given the answer, what they have written, we will see. See, Transfer of Property Act Section 6 talks about this. So, it contains some exceptions to the general rule that property of any kind may be transferred. So, according to Section 6A of this Transfer of Property Act, the chance of an higher apparent succeeding to an extent estate. Say higher apparent means most likely that he will only succeed. That means most likely that he will only get the property. Okay, that is higher apparent. So just because you are higher apparent, now only you cannot think that, I will get the property and now only I will sell it off. You can't do it. So according to Section 6A of TPA, the chance of an higher apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of kinsman, or other mere possibility of a like nature cannot be transferred. So just thinking that tomorrow anyway I am the higher apparent, I am most likely that I'll only succeed. But that doesn't matter, or that is not a ground to say that today only I am the owner and I'll sell or transfer the property. So Transfer of Property Act will not allow that. So thus A cannot sell the property of B, as it is just a mere chance of an higher apparent succeeding to an estate. Okay, next we will go to 2D. I will read the question. I hope you are having that question paper, document, because otherwise I need to again go to that page and read the question for you. So I'll just read the question. One second. So Reyes draws a check for 50,000 on his own account payable to Faiz. So one person is drawing a check on his own account payable to Faiz, but has only 49,000 in his account. What it says? See, I have given you a check for 50,000, but how much I am having in my account? Only 49,000 is there. So 1,000 deficit. Okay, but I have drawn a check. Now, Faiz presents the same to the bank, but the check bounced due to insufficient funds in Ray's account. So now what happens? See, this is simple. I have issued you a check of 50,000 rupees. But in my account, balance is only 49,000. That means what? Full amount you are not going to get. When full amount is not there in the account, the check will be, it will be bounced. So that is dishonored. The whole amount will be dishonored. You will not get even a single rupee. So now it is, I know that I have given you a check for 50,000, but I have only 49,000 in my account. So the check automatically it bounced. So now this is the story. Okay. What is that they're asking? Uh, So whether the above matter, this whole problem can be referred to amicable settlement through the mediation. So can we go? Is it that you have to go to the court only, or can you go for out of the court settlement? Amicable means friendly settlement through mediation or anything. Is it okay to settle through mediation, or you have to go to the normal court only? That is out of the court settlement, or that is alternative dispute resolution. Is it possible or not? That is the question. So we will see this. So they've given a reference of a case law. So if you remember, right? Otherwise, at least you can write as per the provisions or as per the decided case law. Like that, you can start. See, I am not encouraging you not to write the case law or section name or case law name. Though if you know 100%, please quote. It definitely has a weightage. Okay, you will get marks. But I'm telling, because there are a lot of chapters, so much of syllabus. So in case if you forget or if you get confused, don't take a chance by writing or quoting a wrong case law. So in the matter of Dayavati versus Yogesh Kumar Gosan, so this, the question before Delhi High Court was whether under 138 of Negotiable Instruments Act, whether it can be referred for amicable settlement through mediation. So that is if there is, under Negotiable Instruments Act, there's a dispute. Can that be taken to mediation? Alternative dispute resolution is possible or not? So then the court held that even though an express statutory provision enabling the criminal court to refer the complainant and accused person to alternative dispute mechanism has not been specifically provided, however, CRPC does permit and recognize a settlement without stipulating or restricting the process by which it may be reached. So in one of the case, what it is told is, court says is, see, even though if you observe, nowhere it is expressly mentioned, because see, bounce of a check bounce is a criminal offense. Correct? It is because knowingly it gives an image that I know, still I have issued a check. Correct? No, because first of all, in my account, what is the balance I should know. In spite of knowing that I have a less or a deficit balance, still if I issue a check, that is, it's knowingly doing a mistake. No, so check bounce is a criminal offense, you will be knowing. So that is why express provision, nowhere it is there that criminal court can refer to ADR and all those things. But also there is no express ban on referring case to these kind of cases to ADR also. So it will permit. So CRPC will permit. So does permit permit and recognize settlement without stipulating or restricting the process by which it may be reached. So thus there is no bar to utilizing the ADR, including it can be arbitration, mediation, conciliation, whatever. So for this purpose, you can go for ADR. So now in writing your answer, or in your answer, what you have to mainly concentrate is, first you have to tell, see, as per Negotiable Instruments Act, just you have to write, this is a criminal offense. But expressly nowhere it is mentioned that you can court can refer you to mediation or any other ADR. Also, but if you see CRPC, it is permitting. CRPC is permitting. So nowhere it is banned. Nowhere CRPC is banned that you cannot go to alternative dispute resolution, because it is between two people. No, it's not even though it is considered as a criminal offense. But I have to give you money. Yes, I had some genuine reason for because of which I could not maintain the balance in my account. I will show you the bank statement. When I issued the check, my bank balance was 1 lakh rupees. Due to some emergency, it can be any medical emergency or any other emergency, I had to withdraw some money, and because of that there is deficit, and because of which your check has been dishonored. So like this, if I explain, maybe you can consider like going for an alternative dispute resolution. You may not be wanting to settle it through court. You may feel that it's okay, it's not a criminal offense, so we can explain it to the court, and we can come back to ADR, so that is fine. So it's and or maybe if you feel that the beginning only we will go to ADR, definitely we can go. So nowhere it is barred, that you can't go to ADR. Nowhere it is expressly mentioned also, or CRPC is not barring going to ADR also. So that is fine. So now, finally, what is the answer? Yes, you can go and settle the case through mediation. Okay, so next we will go to question number 3. So, 1 second. Okay. So question number 3, in view of the above case, it can be said that the above matter can be, referred for amicable. See that there's a printing error. So finally, conclusion they are telling, in the above case, it can be said that the above the matter can be referred for an amicable settlement through mediation. So that is how you have to end the answer. So we can go for mediation. Next question number 3. A sells 2 tons of oil to B. Okay, A is selling oil to B and sends 1 ton of oil by road and the remaining 1 ton by ship. So 2 tons of oil, 1 he is sending through ship and 1 by road. Mr. B receives delivery of 1 ton of oil sent by road. Okay, he receives on 11th of August 22. But before he receives the delivery sent by ship, he becomes insolvent in September 2022. So what happens here? Seller becomes insolvent. A is still being unpaid, stops the goods in transit. Whether the official receiver of B, the official receiver of B's, the official receiver in B's insolvency claims the goods. So now decide whether the official receiver will succeed. Also discuss whether A can resell the undelivered 1 ton of oil. See here what happened. A is sending to B 2 tons of oil. 1 he sent by road, which has reached B and he has received it. Okay, so now nothing can be done. When by ship, it has to go. Before it reaches B, we came to know that B has already become insolvent. We have sent the goods, it's on the way. Okay, B has become insolvent and we have not received money for that. Now the question is whether B's official receiver means B has become insolvent. No. So instead of him, official receiver will take all his assets, liabilities, and he will try to clear off all the, pay off all the debts and sell off all the assets, all these things. Okay, that officer is appointed. So whether that person can receive the goods on behalf of B or whether as an unpaid seller, because you have not yet paid the goods and B has become insolvent, he has not yet paid the goods. And now A is waiting for money. But in the meantime, it has not yet reached B. So A is waiting for, he is waiting for the money, but A comes to know that B is already become insolvent. So now, see, A has sent goods to B. Okay, A has sent goods to B. 1 ton, 1 parcel that is by road, what he has sent. So first parcel is received. Second parcel is on the way. It has not yet reached B. But before that, it is on the way. Somewhere it is here. Okay, A gets an information that B has become insolvent. Now, what can be done? whether B has right. B means on behalf of B, official receiver, whether he is having right to receive the goods or whether our A can take it back because he is an unpaid seller. No, he has not yet got the money. See, whether B is insolvent or solvent, B has already paid full money means A is not having any right to take back the goods, but A is still unpaid. He's still being unpaid. Now, can he stop in transit? Can he apply that stoppage in transit and take back the goods? Or B's official receiver, is he having the right? Who is having the right? That is the question. So, if you know right of stoppage in transit, easily you can answer. And also, if that is done, okay, stoppage in transit is done, then can resell the undelivered 1 ton of oil? Okay, actually, the second question is giving you a hint for the first answer. Correct, no? So first answer only if we have to tell, whether B is becoming insolvent or solvent, A has to deliver the goods means how can we talk about undelivered 1 ton of oil reselling? Reselling point only will not arise, no? So kind of a hint, for the first question. So we will see this answer. See, we know that the right of stoppage in transit is a right. So when still, see, right of stopping in transit means what? It is still in transit. So before it reaches the buyer, you can stop. You are having the right only when you come to know that the buyer has become insolvent. Okay, B has become insolvent in our case. So, and even if you see our Sale of Goods Act will not talk about insolvency officially declared by court. Okay, even if you know that the person is not in a position to pay you money, that is fine. You can exercise right of stoppage in transit. So these things you have to mention in your answer. Okay, so the right of stoppage in transit is a right of stopping the goods while they are in transit. So resuming resuming possession of them and retaining until the payment is done. So you can stop in between when it is moving in transit. You can take it back. So when the buyer becomes insolvent, the buyer is insolvent if he has ceased to pay the debts in the ordinary course of business or he cannot pay his debts as they become due. So it is not, see, this is what is important. It's not necessary that is actually being declared as insolvent by the court. So whether he is declared by the court as insolvent or not, our Sale of Goods Act will consider the person as insolvent if we get a correct information that he is not in a position to pay the debts. Is not in a good position financially, he is not in a position to repay means that itself is sufficient for the application of right of stoppage in transit. We don't need any official declaration of insolvency by the court. Okay, if we just come to know that the person is not in a position to repay the debts, that itself is sufficient. Okay, so that's what you have to important, that's what you have to mention. Then the goods in transit means what? They are in transit from the time when they are delivered to a carrier or other bailey, like it can be a wharfinger or warehouse keeper, for the purpose of transmission to the buyer and until buyer takes the delivery of them. So the right of stoppage in transit may be exercised by the unpaid seller either by taking the actual possession of the goods or by giving notice to the seller's claim to the carrier or other person having control over the goods. That means either I am seller, okay, personally I can go take back the goods. It has not yet reached the buyer. It is still in transit. Okay, I will talk to the courier agency or maybe the wharfinger or whatever. I will go and collect it back, or maybe I will give them the strict instruction, don't deliver the goods to that person. Both are they both come under right of stoppage in transit. So in the view of the above, so when you have discussed all these things, you tell that A can stop the goods in transit as B becomes insolvent, hence the official receiver will not succeed. So official receiver of B will not succeed. So that is the answer. Okay, next one is also discuss, can A resell the undelivered 1 ton of oil? So can he resell? Answer is yes, he can resell, but there is some information about giving notice to the buyer. You have to wait, you have to give them the notice, and if the buyer says that buyer doesn't respond only, then you can resell. So and after reselling also, what you have to, if you get a profit, what you have to do, if you incur a loss, what you have to do, all these things are involved in this. So we will see this, we will just go through the answer. So see, where the goods are of perishable in nature, section 54(2) talks about the Sale of Goods Act. So where goods are of perishable nature, or where the unpaid seller who has exercised the right of it can be lien or whatever, stoppage in transit, if he gives the notice to the buyer in see, I can't wait because the goods will perish. If I wait, it will spoil. So now what I will do, I will give a notice to the seller, but I will not give a notice to resell. Okay, the unpaid seller may, if the buyer does not see, I will tell within 2 days. If you reply, okay, I will wait, otherwise I'm going to resell it. So for that, if you don't tender, if you don't reply or you don't respond anything, so then I can resell it. So then he can resell the goods within a reasonable time and recover from the original buyer damage for any loss occasioned because of the breach of contract, but the buyer shall not be entitled to any profit which may occur on the resale. Okay, but if such notice is not given, then the unpaid seller shall be entitled to recover such damages and the buyer shall be entitled to the profit, if any, on the resale. So these things you have to mention, okay, because first thing is, first we have to talk about notice. You have to give the notice that you are willing to, because the goods are perishable in nature, or maybe I can't wait, so I am going to resell it to someone else. So you are giving a notice. For that, if the buyer does not respond, you wait for a reasonable time, like maybe in the mail I have mentioned I will wait for 2 days or 3 days. After that, I can resell it to anybody. And see, I sold it to you, I would have sold it for 100 rupees. But because there is a, the goods have lost its quality, or maybe, it has perished, I have got only 90 rupees. 10 rupees loss, because I have given you the notice, I can recover the loss. Okay. So if notice is given, okay, assume have given you the notice, then if there is any loss, I can recover it from you. And if there is any profit, I can only enjoy. Okay. In the same manner, if notice is not given, then if there is any profit, I have to give it to you. And if there is any loss, I cannot recover it from you. So notice plays a very, very important role here that you have to mention. Then again, further, according to section 54(4), where the seller expressly reserves the right of resale. See, again, this also, you have to write reserving a right to resell. Then, in case a buyer should make default, and on the buyer making the default, if he resells the goods, then the original contract of sale is rescinded, but without prejudice to any claim which the seller may have for damages. So, in the view of the above, A can resell the undelivered 1 ton of oil in accordance with the above provision. So, here you are talking about right, reserving of right to resell, and you're talking about giving a notice. If you give the notice, what happens? If you don't give the notice, what happens? So, but in all the provisions, whatever you consider, you definitely, as a seller, you have the right to resell, because the buyer has become insolvent and it is not yet reached the buyer, it's not yet delivered to the buyer, so you can resell. So for reselling, these are the provisions which you have to explain. Okay, next we will go to 3B, question 3B. See, only question number 3 and 4 are, you may feel a bit tricky. The two in question 4, but after that 5 and 6 are very easy. So direct questions, you can just by seeing the question only, you will only you only feel happy that easily you can answer. So we will see this 3B. I'll just read it out for you. I'll just open that page only. See. The government has notified an order under an appropriate statute in the month of September 2022. So government has come up with the order in the month of September 2022 that no one shall buy or sell a particular explosive, some explosive chemical, except under the license obtained by specified authority. Okay, if you have a proper license, then only you can sell or buy this particular explosive. This is what the government has told. Okay, so that means government has issued a notification under a proper statute only that in September 22, that this is considered as a explosive, chemical, explosive. So this you cannot sell or buy without a proper license. That means you have to, whether you want to buy or sell, you have to take a license from the government. Otherwise, you can't deal with that particular chemical. So this was decided in September 22, and government has issued an order also. Now, Tarun applied in October 22 and has obtained a license to buy. Okay, Tarun is a person who has a license to buy. He can buy now. He has a license. And it was keenly look. He was looking for a person who had license to sell. Correct? No, what we said. The government has come up with the order that you can buy or sell only with the license. So now one person, that is Tarun, he already has got a license from the government to buy. Now he wants a person who is having a license to sell. He is keenly looking for that person. So next up, so Briju, who has no license to sell. Now there is one more person. He has actually no license to sell. He represents to Tarun that he has license to sell and includes Tarun to enter into a contract for the sale of a certain quantity of explosive chemical. See, actually, he has no license. This person, Briju, he has no license. Tarun has license. He wants to buy. He is looking for a person who is having license to sell some chemical. Okay. Now this person, Briju, he says, I will sell. I have a license, I will sell it to you. Now they will enter into a contract. So this is what he has given a wrong information. He doesn't have any license. He says, I have the license, I can sell it to you and I'll sell it to you. Next, on January 12, 23, Tarun pays Briju 50,000 as earnest money. Some deposit, he will pay. After few days, Tarun comes to know that this person is not having license only. Okay, after few days, Tarun learns through one of his friend that Briju has no license to sell. Tarun gives a call to Briju to find the truth. So now Tarun calls him up and asks, see, I heard that you don't have the license only to sell. How did you enter into contract? Now, Briju convinces. He says, yes, as of now, I don't have license, but definitely within some reasonable time, like maybe, before the delivery date, I will get the license. Don't worry. I will take the license and then only I will send the goods to you. So, the convinces Tarun that he shall obtain the license within the reasonable time, that is before due date of delivery, but he failed to obtain it. Now he did not get it. Finally, also he did not get it. Now the question is, can Tarun recover the advance payment made to Briju? Answer with reasons and legal provisions. So now you have to give the answer. The question is this, okay? He has given a wrong information and then he has entered into a contract. So government has issued a order clearly that if you want to deal with this chemical, whether you are selling or buying, you both should have the license. So one person is who is ready to buy, he is having the license, and he is looking for another person who has having the license and who is ready to sell. But this Briju, he misrepresents, he like fraud. Okay, he gives all wrong information and he enters into contract, and 50,000 rupees deposit money also he will take. But later Tarun comes to know that he's not having any kind of license from the government to sell the chemical. So now the question is, so after that he'll come to know, and he will talk to Tarun, he will talk to Briju, and he will this Briju tries to convince Tarun, telling, I will get the license, don't worry. But from the date of delivery also, when he was supposed to deliver the goods, that time also he did not get it. So he failed to get it. Now understand the provisions and legal provisions, and then try to answer whether he can get back the deposit money. Okay, so there are two possible answers are there. Okay, one is this one, which is considered as fraud. One more is another, alternative answer, because the one is considered as fraud and one is, not considered as fraud, because later he convinces, no. So that is why both the, point of view or both kind of answers are valid. So we will see this. So if you can properly give the reasons for your answer, any alternative you choose, both are right. You get marks. Okay, so the definition of fraud, see section 17 of Indian Contract Act, if you see, fraud definition is there. So what is fraud? It's an intention to cheat somebody, correct? No, it is an intention to deceive. So now if you see, yes, the Briju has defrauded the, Tarun, telling that he has license. So the party defrauded can avoid the contract. So if it's fraud, then the party who has entered into contract, he can avoid the contract and he can claim even damages. So mainly, what are the main ingredients? So you have to explain fraud here, because fraud has only, we are trying to tell, yes, fraud has happened here. So you have to tell what are the main ingredients of fraud. So there's a false representation of fact. Okay, it's not mere opinion. So I'll see, he has clearly told, yes, I have the license. And he has made Tarun to enter into contract. That is there, and it's made with an intention. It should be acted upon, and the representation must have actually induced the other party into enter into the contract and so deceived him. Correct? No. See, because Tarun told he has the license, that is because, sorry, because Briju told he has license, that is why Tarun entered into the contract. So this is one more thing which is present. Like, I have given you a wrong information, and by believing that wrong information, you are entering into contract. Had I not given that information, no, you would not have entered into contract. Had Briju not told that, he has license, definitely Tarun would not have entered into contract, because he is very much keen on a person, looking for a person who is having license to sell. So that has made him telling that, I have a license to sell, has made him enter into the contract. So the party deceived must thereby be indemnified. So you have to make good the loss. You can claim the damages. And the statement must have been made either with the knowledge that it was false, or without the belief in truth, or recklessly without even caring whether it was true or false. Correct? No. So this is correct. Because if maybe Briju would have to, he's just careless. Okay, if I get license also, okay. If I don't get also, okay. I'll just make the statement. I'll give the statement and I'll make you, enter into the contract. It can be that is carelessness, or it may be like, I know I can't get the license, but still just to cheat you. I have given you wrong information. So all this comes under fraud only. It can be either carelessness, or it can be, I know that it is wrong, still I have given you that information telling it is right or truth. False information I am giving. So all this amounts to fraud. And it is immaterial whether the representation takes effect by false statement or it with the concealment. See, whether I am giving you a wrong information, or whether I am hiding proper information, or maybe I am careless, all these things will not matter. But what only matters is whether, based on that information, have you taken the decision, and because of that, have you suffered loss? If yes, then that is a fraud. So that is what it says. Then, see, misrepresentation is different. Okay, don't get confused there. I'm telling, I know it is wrong. Maybe I am careless, or I have an intention to cheat you only. So it can be anything. But based on that, if, or maybe, I'm giving you wrong information, or I'm hiding an important information, but I have an intention to either cheat you, or maybe I'm just careless. Okay, then I know it is wrong, but that information only I've given you. That is fraud. But without verifying, thinking that it is right, if I innocently tell you something, no, that is no misrepresentation. I'm not talking about misrepresentation here. So therefore, if it is, by looking at these ingredients of fraud, if you consider it as fraud, if you take this situation, if you apply this situation to Tarun and Briju case, definitely it can be considered as fraud, and the contract can be avoided, and Tarun definitely can claim 50,000, whatever deposit money he has given, he can claim from Briju. So therefore, Tarun can recover the advance payment which is made by him, because it is voidable on account of fraud committed by Briju. Thus, Tarun can rescind or cancel or avoid the contract, and even he can sue for damages. Also, Tarun has right to claim compensation for any damage which he has sustained through non-fulfillment. Because of non-fulfillment of the contract, if he has suffered any loss, that loss can be recovered. That is one way of answering. Another alternative is there. So if you feel this alternative is more apt, you can write this also. Both are accepted by the institute. So avoidable contract is initially considered as legal and enforceable, but can be rejected by one party if the contract is discovered to have effect. See, one voidable means what? You are trying to tell why voidable is what? Initially it was all valid only, but later there is some defect, so you want to avoid it. That is voidable. So if a party with the power to reject chooses to reject the contract, then despite of the defect, the contract remains, see, voidable means what? If you choose to rescind, you want to cancel, you are having an option to cancel. If you don't want to cancel, that is even now also it will be valid. Like for example, coercion. I will just gunpoint you and I'll tell you have to sign this contract. Okay, you have signed it. If you want to take action and you want to cancel it, you can do it. If you keep quiet, it is still valid, no? So that is voidable. Now, in our given situation, if you take, even though Tarun came to know later that he has no license, Briju has now no license, but Briju convinced, and Tarun says, okay, no, he's continuing. So where is fraud? Like that also you can answer. So now in the given situation, Briju defrauded Tarun to enter into contract. But later on, when Tarun found that it was happened by fraud, Tarun could have avoided. At that time only, you could have told, no, no, I don't want to, continue the contract with you. But he did not do it. He opted to continue. But so now Briju convinced, and Tarun convinced Tarun that he shall obtain the license within the reasonable time. This means that Tarun that does not, he has not rejected the contract and they agreed to continue. So, as because it's actually an illegal contract, but he agreed to continue. It's not even contract; it's an illegal agreement because the government has passed the order. But still, Tarun accepted it. So, in the view of the above, Tarun cannot recover the advance paid if Briju failed to obtain license, as illegal agreement is not enforceable in law because it is illegal. See, when you know that I don't have the license. Immediately, you should have told, no, I don't want to continue. I will cancel immediately. But you did not do it. I tried to convince you, telling, why do you worry? Within 1 week, I will get the license. As of now, as of today, you should have thought, yes, it is illegal. We should not do it. It's not enforceable. You did not do it, no? So you opt to continue. When you opted to continue, even though it is voidable or whatever it is, it becomes valid. So it becomes like that. Voidable is that. But in our case, if you see, it is completely illegal only. It is illegal because government only has told. See, now you are explaining what is voidable, what is valid, and what is illegal. If you opt to continue with a normal voidable contract, it will become valid. But now, in our case, when you know that it is illegal, that is going against the government rules and regulation, you should have avoided then and there itself. When you did not do it, it is taking the color of illegal agreement. When it is illegal agreement, you cannot recover any deposit. You can't do anything. It is as good as you have only accepted it. So it's like that. You can take your answer as fraud, or you can say this is it was what is voidable, what is valid, and what is illegal. And you can say in our case, as he only accepted it, there is no fraud. See, in order to tell fraud, I have to cheat you from the beginning till end. But here it's not cheating. Yes, I made you sign the contract, but later I accepted. No, I tried to convince you. Why did you get convinced? That is mistake from your side. So now you can't recover. So both the stand you can take. Both alternatives are right. Whichever you feel, it's right, you can write that answer. So both is fine. You can try, you will get marks. So next we will go to 3C. John, who had, okay, I'll read it. See, all these are for 5 marks. John, who had his account in a private bank, went to bank to deposit the cash. Okay, so I have an account in a bank and I go and deposit the cash. I want to deposit the cash, so I went to bank. While he was entering into the bank, alongside cash box of the bank was also being carried inside. See, I want to go and deposit the money in my bank account. So I have gone to the bank, but next to me a cash box is carried. A cash box is carried. So now there will be security and all these things. So next to the cash box, I am going. So security guard sees me and he feels that, immediately he feels that he has to take an action against me. See, I am innocent. I have no idea to, loot the bank or take that cash box, nothing. I just want to deposit my cash and, I'm in my account. So I have gone to the bank. But next to me, there is a cash box which is carried. So immediately security will shoot me. Okay, that means that person is killed. I'm killed. So now what action you will take? So that is the question. Okay, see, while he was entering into the bank alongside the cash box of the bank, alongside cash box of the bank was also being carried inside. So the security guard in a haste, in an urgency, in a haste, he ended up firing John, thereby killing him. Now, wife of John, that is Mrs. Maria, claims that the bank is vicariously accountable. Correct? No, because the servant has done the mistake, so master is also responsible. So they are trying to file a case against the bank. Your employee has done, it's for your good only he has done this. No, in order to protect the cash of the bank, cash box of the bank, he has done it. So you are responsible. So this is what Mrs. Maria is telling. That is deceased wife. So for this accountable for the incidents, and but the bank argues that it had not given the permission to employee to fire. Bank says no, we have never told our employees to fire. Okay, they can. We have just told them that you have to threaten them if they come. If they try to come near the cash box and all those things. But we have never told our security guard or employees to kill anybody. So now, is this argument of the bank is correct? So answer. So now what we are talking about is vicarious liability. Okay. So now we will see this. General principle. What is vicarious liability? Just two lines you explain. So that is we facet per alium facet per se. That means one who doesn't act through another is deemed in law to do it himself. See, I am working for bank. I have done a mistake means it is for the good of the bank only I have done. So bank is also, see, that doesn't mean that I will be, I'll not be given any punishment. I will also be given punishment. Automatically, my bank, that is my employer, will also be responsible because I am acting because of them. Whatever they have told, it is just their ideas or their instructions I am following, or for their good I am doing. That is what is considered in vicarious liability. So this you have to explain 2 points. And respondent superior. So, sorry, respondent superior. That means let the principal be liable. So we have to always make the employer or principal be responsible for the actions of the subordinate. So these, whenever you get any question regarding the vicarious liability, these terms you have to write. Okay, these terms you have to be careful. You have to write. Then, so it's kind of a secondary liability. So what is vicarious liability? In your own words, you can explain. So such liability arises in case of master and servant. So all these things in the course of employment, all these things you can write. So an act is said to be in what is so in the course of employment means what? It is a master has directly authorized the act to the servant. Master has given the instruction, that is what he is doing. Or maybe the act is done, the act done is authorized, but act done wrongly. That means, see, bank has told, okay, take care of the cash box. Okay, either bank may, first thing is bank has told you can fire anybody. In our case, that bank has not told. But the second one is the act done is authorized, but act done is authorized, but it is done wrongly. That means bank has told, please take care of the cash box when it comes inside. No, please take care of it. Just to take care means he has taken care, but in a wrong manner. That is short. That is wrong. So now in both the manner, in both the situations you take, our employer is responsible for the action of the servant. So bank is vicariously liable, and Mrs. Maria, that is the wife of the deceased, whatever she is claiming, she has filed the case, no, that is 100% right. So, the facts in the instant case, however, very clear that the incident in question took place when the cash box was being carried into the bank premises and the deceased was also entering the bank premises. So, if the security guard has committed an error in perceiving the act of the deceased as a threat to the cash box, we see why he's doing all these things. Because if anything happens to the cash box, that is a direct loss to the bank. It's not loss, nothing will happen to his salary or his money. It is a bank's property. There's a direct loss to the bank. In order to avoid that, he has done this act. So bank should take the responsibility. So he's expecting a possible danger from the third party, so he is trying to avoid it. So the act of the security guard causing death of the deceased, that is John, was in the course of the employment, and therefore it is not possible to accept the defense pleaded by the bank that it is not vicariously liable. That means whatever Mrs. Maria is telling is right. Bank is vicariously liable. Next, we will go to question number 4. So here you have two choice. Okay, under 4, you have 3 questions. And or you have an alternate, again 3 questions. So either first set of 3 questions you can first set of 3 questions you can answer, or in 4A set of 3 questions you can answer. It's not like one question from 4, one question from 4A you answer. No, either you have to select all the 3 from 4 or all the 3 from 4A. So that is the choice you have. So we will see this one by one. First one, under the Limitation Act 1963, the limitation period for filing a particular suit is 3 years. When the limitation period commenced, Akash was minor of age 13 years. See, due to his legal disability, he could not institute the suit. So this we know, when you are a minor, legally you are disabled from instituting the suit. So this is a question related to legal disability. So that immediately it should strike to your mind. This is Limitation Act, legal disability, because that person is a minor. Now the question is, decide with the reasons whether Akash can file the suit on cessation of the minority. That means once he ceases to be a minor, that means once he attains the age of majority, can he file the case? As of now, he is having the right to file. That means he is the person who has to file the case, but he is minor. Minor legally disabled from filing a case. Now what can be done? As per Limitation Act, you have to answer. So for this, you have to mention section 6, 7, and 8 of Limitation Act. So just one sentence if you explain also, that is what 6 says, what 7 says. 8 is an exception to 6 and 7. So just 7 also not completely you need to explain, but 6 and 8 you have to concentrate more. So that much if you explain, that is sufficient. So see, just this much if you write, just 2 paragraphs, you get 5 marks. So section 6 says, it's an enabling section. It says that it talks about disability to exercise legal rights within a certain time. So section 7 also talks about that only, when in a group of people, if one person is legally disabled, so what to do. So that is section 7. And section 8 is a controlling section or an exception to section 6 and 7. That means whatever may be the legal disability, maximum time period we are allowing is 3 years. So that section 8 says. So by considering all these things, Akash can file a case because now he is 13 years old. He is not legally able or not legally, he can't file the case. So the limitation period says, or Limitation Act says, it waits till his legal disability is removed. And once he attains the age of majority, within 3 years, because that limit is put by section 8. Okay, so within 3 years, he can file the case. So that much clearly, if you explain, those things you have to include in your answer. Section 8, you have to include 3 years maximum you have to mention, and section 6 you have to mention. In the end conclusion, you have to say Akash can file the case. So this exception applies to all suits except suits to enforce the rights of preemption. So apart from preemption rights, for everything this is applicable. And further, the period of 3 years has been counted not from the date of attainment of majority by the person under legal disability, but from the date of cessation of minority or disability. That, see what it says, the last part, that is, it's that last sentence further is there, no? This sentence is giving the person who is evaluating in your answer even more a clear idea that you know everything about this provision. Okay, what is that? See, you need not calculate from the date he attains the age of majority. From the date his disability is gone, no, ceased. From that day, you have to consider. What does that mean? That means, see, a person is minor. Tomorrow he will attain the age of majority. Okay, tomorrow he will attain the age of majority. Actually, from day after tomorrow, the 3 years time limitation period will start. But tomorrow he meets with an accident, or today only he meets with an accident. He has gone to coma. From tomorrow, if you start calculating 3 years, almost 2.5 years he is in coma only, you'll get only 6 months, no? That is why they are telling. So don't tell from the date of attainment of majority, not that. Tell from the date when he ceases to be legally disabled. That means from the date when he becomes legally abled, from that day he will, that 3 years will be counted. That you have to, that is an additional information which makes sure, or which shows to the evaluator that you are 100% sure of the provision. You completely know further that the period of 3 years has been counted not from the date of attainment of the majority by the person under disability, but from the date of cessation of disability or minority. Okay, so that's what I told. So he from tomorrow he will become major, but today he meets with an accident. What to do? So that is why. Okay, so thus he can file a suit after he attains age of majority. So three. That is 4A. Next we will go to 4B. See, here they have mentioned a case law, but if you understand section 79 properly, no, you can answer. Okay, you can give the answer. So we will see this. So does section 79 of Information Technology Act as originally enacted deal with the effect of other laws or not? That means whether section 79 is dependent on any other law or it is independent. Section 79 itself is one proper provision or a section, or is it dependent on any other law? That is the question. Answer is no. Okay, it is originally enacted only. It's not it does not deal with effect of any other law. It is originally enacted. That is the answer. Because we know section 79, if you know, you can tell that. Then answer in the light of decision by Supreme Court in Google India Private Limited versus Vishaka Industries and others. So that one case law they have given. So what happened there and what is section 79? This is what they have asked. At least if you assume you don't know properly about this case law, even though that is fine. At least the first part of the answer is properly you can explain and you can score up to 2.5 to 3 marks. Okay, so at least if you know that, or you can anyway opt for alternative, but I'm just telling if there is no alternative, if it is not question number 4, then also that is the first part you can easily answer. So this also you can answer. I mean, that is an important case law only. Still, if you at least if you are not sure of that also, first part if you answer, then also there is a great high chance that you will get 2.5 to 3. Two at least we will stick to 2 marks minimum. That will be guaranteed. Okay, so we will see this. See, what is first 79? It talks about intermediaries. Okay, responsibility of intermediary. That means like a Google search engine, or it can be just dial. So it's like they are receiving. I need some information, or maybe I want to send you a mail. I want to send you a mail. So this intermediary will receive my mail, and then they will in turn send it to you. I have to send you a mail means they will receive it, and then they will in turn send it to you. So there is an exception for them. See, each and every communication between crores of together people, everything, they can't keep a track. They will have a track on it, but everything they can't verify. It is just that, the properly they are maintaining, security features and all those things. Reasonably, if they are maintaining those things, that is fine. But each and everything, if you try to make them liable, no, nobody will render that service only. So that is 79. First thing you will explain that. And then you say it is originally enacted. Okay. Later, we will go to that case. So it says, intermediary shall not be liable for any third party information, data, communication link, whatever. So according to 79 2C, the provision of subsection 1 shall apply if the intermediary observes due diligence. See, if you are reasonably careful and if then also if there is something wrong, then you need not worry. Okay, so provisions shall apply if the intermediary observes due diligence while discharging his duties under this act, and also observes that such other guidelines as government has prescribed, central government has prescribed the guidelines, and due diligence, if you observe, that is sufficient. You need not worry about each and every message, each and every mail. You need not worry. So that is one thing. So now if you take up this case, Google India Private Limited versus Vishaka Industries, what Supreme Court has told is that it is originally enacted and it did not deal with any effect of other laws. So this much you have to write. This much you can easily write. Correct? No, see these 2 paragraphs, if you write only, you get half of the marks. Next. So we will go to this. What happened in this case? So this you have to be careful, that you have to clearly mention that, it is originally enacted. It did not deal with the effect of other laws. Because of the other law, this section has come into existence. No, that is what they are asking. Is it because of CRPC or is it because of IPC or any other law this has been enacted? No, this is an independent original enactment or original provision. So it is not deal with the effect of other laws. So that much you are clear. You have to write. Now we will see what to be written in case of this case law. So Supreme Court decided that the finding by the High Court in that in case on hand, in spite of the complainant issuing notice, bringing it to the notice of the appellant about the dissemination of defamatory matter on the part of the first accused through the medium of appellant did not move its little finger to block the said material to stop dissemination and therefore cannot claim exemption under Section 79 of the Act as it originally stood. It afflicted with two flaws. So here Supreme Court told something. What is that? See, mainly this Google case is, see, a person was insulted on the Google this platform. Okay, reviews we give, no. So there was a completely defamatory matter was published. Now this, they wanted to, tell the Google that is, see, this you have to remove. About us, some defamatory matter has been written. This you have to remove, you have to delete it. But the Google did not, see, that is what it says. Appellant did not move its little finger to block the said material. See, when you come to know, see, as per 79, you can take exemption from telling that I'll not be liable, I'll not become liable because daily I'll be seeing crores of together messages or whatever you reviews. So everything I can't watch, but I am just exercising due diligence, like something maybe few words, usage of such words are prohibited. If that word is used, I have to be careful. So like this, some due diligence and other proper guidelines of the government, everything I am following. So then you can claim exemption. But in this case, what happened specifically, they have told Google to remove that particular comment or a review, but they did not do it. Okay, they said they did not move even a little finger, means they did not worry at all. So I'm telling, see, something bad about me in your platform is written. Please, take it into consideration. My request, you please take into consideration and remove that. But they did not do anything. That is wrong. When you come to know, as an intermediary, when you get an information or a complaint, you have to be careful. You should take some action against it. You should verify, but you did not do anything. That is a flaw from your side. That is what Supreme Court tried to tell you. Every time you can't take exemption telling Section 79. Okay, in the first place, the High Court itself has found that Section 79, as it originally enacted, had nothing to do with the offences with other law. First thing is, it was originally enacted. And we have also found that Section 79, as originally enacted, did not deal with the effect of other laws. In short, since defamation is an offence under Section 499 of IPC, Section 79, as it stood before substitution, had nothing to do with freeing of the appellant from liability under the said provision. That means what? They try to tell, this is defamation, IPC, all these things. Okay, you have to talk from, see, for example, I have written some bad review about you. I have written some bad review about you. Now, you went to Google and you told, see, please remove this, you should be deleted. It's unnecessary defamatory matter. I'm not like that. See, if you are really maintaining all, giving kind of bad quality products or rendering bad services, okay, you have to accept it. But you are really good at what you are doing. Now you can tell it is complete defamation. You will go to Google and you will tell, please remove this. But Google is trying to take shelter telling Section 79 exemption, and it is completely a defamation. If it's defamation, you go and file a case against a person who has written. Why are you, troubling me? So this is where Supreme Court told no. So 79 and 499 is not related. 79 itself is the original enactment, and 499 is defamation. That this person, he will file a case against a person who has actually written. But the thing is here where you have gone wrong is when the person is telling you that it is a defamation. Please, from your platform, you are having a right to remove that. Means you have to delete it. You have to remove that. Why you did not do it? So you can't take a shelter telling, Section 79. And it's 79 is not dependent on any other law, nothing. That is independent. You have to be you have to carry out the due diligence procedure. That means you have to be diligent, properly, carefully. You have to see what kind of materials or what kind of information is sharing using your platform. Plus all central government guidelines you have to follow. But when you come to know that there is something bad about a person is written on your platform, you should have been careful. So this is what you have done is wrong. So section 79, so it is originally enacted and it does not deal with effect of any other laws. So next we have section 4, question 4C. I'll just read it. So this is related to CRPC and Article 21 of Constitution. So we will see this in the latest decision of Supreme Court, that is in case of Satendra Kumar Anil versus CBI and others. It took a note of continuous seeking bail after filing a final report on a wrong interpretation of Section 170 of CRPC, and thus made an endeavor to categorize the type of offences to be used as guidelines for the future. It issued the directions for investigating agencies and also for the courts. However, it cleared that these directions may be subject to state amendments. His right to bail is on touchstone of Article 21 of Indian Constitution. State the direction issued under the case. See, this is related to bail. Okay, first thing is this case, in this case, that is Satendra Kumar Anil versus CBI, this case is related to bail. Continuously, you are filing bail application. And the thing is, in this case, court has given certain guidelines. Guidelines means it is not mandatory. Exactly like that only you have to follow. It's not that, but you have to take it into consideration, and according to your state, whatever is the requirement, you can take it into consideration. So now, whether it is a touchstone of Article 21, that is a question. So what is touchstone? Touchstone means it is a criteria on which the decisions are made. Okay, criteria on which the decisions are made. So that means when you are talking about a bail or any guidelines given by the court, whatever, so is it a touchstone of Article 21 of Constitution? Means is it a criteria for deciding, for say making some decision? Is it a touchstone or Article 21? So these things you have to tell, you have to answer. So state the direction issued under this case. So in this case, few guidelines are issued. Okay, only those guidelines you have to mention. So we will see what are those guidelines. So taking this case as reference, no, some guidelines, some points are told by the court. So those points you have to write it as it is. So it says, see, in that case, taking a note of continuous supply of cases seeking bail after the final report on a wrong interpretation, say 170 only wrongly interpreted, and so then there is an endeavor which is made by Supreme Court to categorize the type of offences to be used as guidelines for the future. So Supreme Court has given few guidelines with respect to, in this case, taking this case as a base where there was wrong interpretation of Section 170, some guidelines, some points have been issued. So Supreme Court has told something. See, if you remember this, all these things exactly, because Supreme Court has told that, and you have to write it in court, means you have to write it as it is. If you remember, you write. Otherwise, you can start with write about this, just one paragraph of introduction, and directly you can start with those guidelines. So it said the principle that bail is a rule and jail is an exception has been well recognized through the repetitive pronouncement of the court. This again is on the touchstone of Article 21 of the Constitution. That means whatever guidelines, whatever decisions we are making, no, everything you have to keep in mind Article 21 and then do it. So we know that if you go any law, any rule, any regulation, bylaw, whatever, if you go against the Indian Constitution, especially these Article 19 and 21 and all those things, that rule, bylaw, or regulation, whatever, that will be considered as void. Correct? No, that we know. So that is why Article 21 you have to keep in mind. It's a criteria for decision making. So that is what it says. Again, all these guidelines, again, it's on the touchstone of Article 21 of Indian Constitution. So further, it has issued some guidelines with respect to the state amendments. That means guidelines means it is not mandatory. Whatever is applicable, how much ever you can follow, that much you can do it. So these directions are meant for investigating agencies and also for the court. So everybody should follow this guidelines or direction. So we will see what is that. So that is first one is the government of India may consider introduction of a separate enactment in nature of a bail act. So it has to streamline the grant of bail. See, there is lot of confusion when it comes to granting of bail. So that is why for bail only you can have one act, one legislation, one statute for bail. So you can have that. That is first guideline. Next, investigating agency. So you can be a CBI, you can be a court, whoever you are. So investigating agencies and other officers, they are duty bound to comply with section 41 and 41A of the code. So you have to follow section 41 and 41A. So whether you are a court, whether you are a police officer, you are in any investigating agency, you have to keep in mind 41 and 41A. So any dereliction on their part, that means if you divert, if you don't respect that, then it has to be brought to the notice of the higher authorities. So you can give a complaint if they are not following 41A. Then the courts will have to satisfy themselves on the compliance of 41, and so court also should see to it that 41 and 41A is followed, and any non-compliance would entitle the accused grant of bail. If you don't follow 41A, no, immediately accused can be granted a bail. Then all state government or union territory are directed to facilitate the standing orders for procedure to be followed under section 41A of the code while taking the note of the High Court of Delhi dated 7/2/2018. That is a writ petition and a standing order issued by Delhi police. So if you are a state government, any union territory, you should facilitate standing orders with respect to following of 41 and 41A. So this is another direction. Then there need not be any insistence of a bail application while considering the application under section 88, 170, 204 and 209 of the code. So all this, talks about, 209 is committing a case to session court, and then 88 talks about a bond. So these things, there need not be any insistence of a bail application while considering application under section. So when you are considering an application under section 88, 170, so there should not be any insistence of a bail application. Then there needs to be a strict compliance of the mandate laid down in the judgment of the court in Siddharth, that is Supra, that is the case given above. Then state and central governments will have to comply with the directions issued. See, this is as it is given, and you have to write all the directions or all the points. So state and central governments will have to comply with the directions issued by the court from time to time with respect to constitution of special courts. So if there is any constitution of special courts, then the state and central government should follow that. Then the High Court, in consultation with the state government, will have to undertake an exercise on the need of special court. So when there is a need for special court, High Court should have a discussion with the state government, and they can start a special court when there is a need. Then the vacancy in the position of presiding officers of the special courts will have to be filled up. So when just it's starting a special court is not sufficient, you have to get the officers also appointed. Then high courts are directed to undertake the exercise of finding out the under trial prisoners who are not able to comply with the bail condition. After doing so, appropriate action will have to be taken in the light of section 440. So that means if if a person is not in a position to give the amount of deposit and then take a bail, so you have to consider them. And if there is 440 talks about reduction in the bail amount, all these things. So it talks about amount of bond and reduction, all these things. So you have to consider section 440, and if any discount or reduction you can give, that you can give, and then grant them the bail. Then while insisting upon sureties, the mandate of section 440 has to be kept in mind. So what 440 says, before insisting that this many number of surety should come, this many amount of deposits, this you have to deposit, all these things. Before telling all these things, you have to consider section 440. Then an exercise will have to be done in similar manner to comply with mandate of 436A. both at the district and judiciary level and high court as earlier directed by this court in Bhim Singh, followed by appropriate orders. Then by bail application ought to be disposed of within the period of 2 weeks. So maximum it can be 6 weeks, but within 2 weeks you have to complete the bail application. Then all state government, union territory, high court are directed to file affidavit or status report within a period of 4 months. So these are some of the directions which is given by Supreme Court. Okay, so in view of above mentioned, it can be said that right to bail is the touchstone of Article 21 of Indian Constitution. So right to bail is mentioned in the Article 21, and before you grant the bail or you reject the bail, or before you come up with any rules and regulations with respect to bail, you have to keep in mind Article 21. That's what it says. Because this is as it is the directions you have to write. So those points you have to keep in mind and you have to write it. Then we will go to alternate, that is 4A. The first question is explain the ground for setting aside of an award under the Arbitration and Conciliation Act 1996. See, this is easy, direct question. So you have to just explain the grounds. Okay, 4A1. So when that is section 34 provides that provisions relating to ground for setting aside of an arbitral award. See, there is an option or there is a provision that if there is arbitral award has been passed, that itself is not final. If you can prove any of the following given circumstances, if you can prove any of the point, then you can set aside. That means that arbitral award can be made invalid and the court will give a different judgment. So if you are not happy, see, if you are not happy with the decision of a court, you can go on and appeal. No, in the same manner, award can be set aside. So those grounds directly, whatever is given in your book, that much if you write, that is sufficient. So it can be set aside by the court only if a party was under some incapacity or arbitration agreement was not valid, or maybe it was not valid under the law to which the parties are subject, or failing any indication thereon under the law for time being in force. So against the law, you have not properly drafted the arbitration agreement, or maybe the party making the application was not given a proper notice of the appointment of an arbitrator or of the arbitral proceedings. So when any arbitral proceedings is carried on, or maybe when an arbitrator is appointed properly, you have to inform to the other party. If that is not done, you can always, it's a ground for you to set aside that arbitral award. Then arbitral award deals with the dispute not contemplated or not falling within the terms of submission to the arbitrator. That means arbitration agreement you have written for these disputes, we will refer to arbitrator, but instead of that some other dispute you have referred to arbitrator, which is not there in the agreement only, then that is wrong. Okay, so if there are things which, like, for example, criminal offenses, you can't go to arbitrator. If there is a kidnap or murder, you can't go to arbitrator. So there is one kidnap case and one partnership dispute. So two separate two separate disputes you have filed with the arbitrator. Okay, partnership dispute and kidnap, if you can separate it, kidnap will be made void. Decision on kidnap or arbitral award on kidnap will be made void because it is completely wrong. It the arbitration arbitrator or arbitration council is not having that right only. So if you can separate it, so that you can leave it and remaining you can make it valid. Otherwise, everything you can make it invalid and everything will be set aside. Or maybe composition of the arbitral tribunal or the procedure was not in accordance with the agreement. See, now we have decided that we will have 3 arbitrators, but you appointed only one. And that one arbitrator has passed the award also. Now I can tell, see, arbitration agreement says 3 arbitrators, but you have only appointed one. This is wrong. So like that. So composition or any procedure. So those things you can, those are the grounds where you can say that, arbitral award is wrong. It has to be set aside. I'm not happy with this. Okay, unless such agreement was in conflict with the provisions of this part from which parties cannot derogate, or failing such agreement was not accordance with this part. So that means whatever you have agreed, they've completely deviated from that. Then you can claim a setting aside of the award. This is party should, claim this. I mean, party who is asking to set aside, who is requesting to set aside the award, he should prove But next one is, if court only finds these two things, this also you have to write. The court finds that, the heading is important. Okay, if court only finds that the subject matter of the dispute is not capable of being settlement, like I told you, criminal and civil case. This one you can take, like, where you as a party, if you have to prove, assume two disputes you have referred to arbitrator. One is against the agreement. In agreement, it is not written only. One is written in the agreement. Okay, one is partnership dispute, maybe related to profit. Another is related to loan. Loan arbitration, we can't go. Okay, because in the agreement, we have not written anything about it. So this you have to prove. But if it is like I told you, criminal case, which is not arbitrate, arbitral council is not having the right only to deal with those cases, then court will only tell immediately, yes, we will set aside the award. Like that, the subject matter is not capable of settlement by the arbitration, or arbitral award is in conflict with the public policy of India. So what is public policy? Mainly, you are going against the rules and regulation, you are not following the confidentiality. So these things, okay, we will see explanation has been given what is against the public policy of India. So to avoid any doubt regarding what is against the public policy or conflict with public policy of India, it means the making of award was induced or affected by fraud or corruption. That means you are an arbitrator, I have given you money and I have told please give me award in my favor only. That is against, or in violation of 75 or 81. That is, confidentiality is very important in arbitration or conciliation, whatever. So if that is not maintained, that is wrong. That is, as an arbitrator or as a party, I will go and discuss what is happening in our arbitral proceedings with everybody. That is wrong. Or maybe it's something which is against the fundamental policy of Indian law, going against the government rules and regulation, or it is conflict with the basic morality, notion of morality or justice. So in these things are considered as against the public policy of India. So again, one more explanation is there. So, for avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Further, an arbitral award arising out of arbitration other than international commercial may also be set aside by the court if court finds that award is vitiated by patent illegality. That means if you apply, patent illegality means the core of the law itself you have applied wrongly. It is not just an error. Patent illegality means the core understanding of the law itself is wrong. Completely, wrongly you have applied the law, and completely you have gone against the law and you have given some decision. So then court will consider these things and it will give you, grant you setting aside of the award. Okay, these two explanations you have to write. At least explanation, first explanation is very important. Okay, at least this one you have to write all the 3 points. What is against or conflict with public policy of India? Okay, explanation 2, if you don't remember, at least this much. It shall not entitle a review on the merits of the dispute. At least that you write. Or if you don't know, at least explanation 2, if you don't write, also it's to some extent okay. I'm not telling you don't write, but at least okay. But explanation 1, so you should not miss. Okay, next we will go to 4A2. Explain the concept and verification of e-stamping. So e-stamping means what? It can be generated within minutes, and it has, you can verify going to the SHCL website. So all these things, it will have a unique number. And if you go to that website and, if you put that unique number, date and all those things, you can verify that, whether it is a fake or original. So these things you have to explain. Okay, that is easy. So we'll just see this. See, this same thing, your e-stamping is computer-based, secured electronic way of stamping the document. And, they're giving information about SHCIL, that is a central record keeping agency. And through modernization, there has been introduction of e-stamp, or it's known as electronic stamp. It's a computer-based secure procedure to obtain non-judicial stamps. And, it's this prevailing system of physical or franking is being replaced by e-stamping system. How to verify? So Yeah, and in-stamp can be verified. So all these things you have to write by clicking on verify e-stamp certificate and entering the required details. That is the state, certificate number, unique, identification number, then the type of stamp duty, then date, then you have six character alphanumeric string. So all these things, if you put it, no, when you go to this www.shclestamp.com, there you can verify. You will get to know whether that stamp paper, whatever you are using, is original or fake. So easily within minutes you can verify it. So UIN is a unique system generated number mentioned on the stamp. E-stamp certificate you get, no, on that this UIN will be mentioned. Anybody who is having UIN can check the authenticity of the certificate. Okay, next question is 4A3. I will just read it out because this is easy. They have just asked the difference between the electronic and digital signature. So, Information Technology Act 2000 provides legal framework for electronic governance by giving recognition to electronic records and digital signature. So often digital signature, see, usually what they have told is, usually people consider digital and electronic signature as same. Is it same? If not, differentiate. Is it correct to consider both as same? Discuss. So it's not same. We know no that electronic and digital signature is not same. So first sentence, what you have to tell, electronic signature and digital signature are not same as per this IT Act. So now we will tell the difference. And whenever you get differentiating between those kind of questions, no, avoid writing in paragraph. Like this only you write table. Even if it is for 2 marks or 3 marks or 5 marks, don't worry. Okay, if it is for 5 marks, at least write five differences or six, one extra. Okay, like that. And always write in form of a table only. Don't write in paragraph because it will be difficult to find where exactly the difference is. You write in paragraph, then he has to, the person who is evaluating, no, he has to check where you have written, what difference you have written. So it takes a lot of time and maybe he might get irritated. So instead of that, like this table presentation, if you do, it is easy for him also to know that you know the difference and you've written it properly, and easily you will get marks, high good marks. So you have this basis of distinction, then you have electronic and digital signature. So definition is given in 2.1p, that is digital signature. And if you see electronic signature, definition is there in 2.1ta. Then meaning, it's a digital form of web link signature that is legally binding and secure. But digital signature is a secure signature that works with electronic signature and relies on, see, there is a public private key, all these things. But in electronic signature, these things are not there. Purpose is, it is used to verify a document. Here it is for securing a document. Then validation is not performed. See, there is no like DSC, we don't have any validation technique or all these things for electronic signature. But that is possible in case of a digital signature. Then security, see, it is vulnerable to tampering. There are possibility that electronic signature can be tampered, but digital signature is highly secured. And electronic signature, again, verification, validation, all these things are not possible. But digital signature, it is possible. Then types, it can be verbal, electronic, ticks or scanned signature. These are common types of e-signature, but digital signature they include in Adobe and Microsoft. Then utilities, electronic signature is easy to use, and when it comes to taking it as an evidence, it has less evidential value. But generally, digital signature has more evidential value and more authentic. Okay, next we will go to question number 5. So for this, the first question is, all these are 5 marks each. First question talks about Right to Information Act 2005. It says RTI specifies the manner in which requests may be made by the citizen to the authority for obtaining the information discussed. See, for obtaining the information, we have the right. Correct? No? What is that? You discuss. That's all. The answer you have to write is how we can make an application, whom we have to, which officer we have to approach. That's it. That much if you write, you get 5 marks. Okay, so you'll see. See, according to section 6, any person who desires to obtain any information, okay, shall make a request in writing. Okay, through, or it can be in writing, or it can be any electronic means, in Hindi or English or any official language of the area in which the application is made. So and nominal fees you have to pay along with that. to whom you are making these two officers are important. That is Central Public Information Officer or State PIO, as the case may be of the concerned public authority. So if you want information from the state government department, then you have to make the request to State Public Information Officer, or if it is a central government department like income tax department or anything, you have to make application to Central Public Information Officer. Or if it is a sub district level, then you have to ask the central assistant PIO or state assistant PIO, specifying the particulars of the information sought from him or by him or her. However, where see, this much you have to write anyway. This is about officers, you have to write. Then later, one more point what you have to add is, if there is a person who is illiterate, who can't write, then that officer should help them in writing the application. However, where such request cannot be made in writing, the central PIO or state PIO, as the case may be, shall render the reasonable assistance to the person making the request orally to reduce the same in writing. Then, an applicant making the request for information shall not be required to give any reason for requesting info. See, no personal data. Only thing is where it has to be sent. Like it can be your phone number or email ID or address you can give. But apart from that, you need not give any of your personal details or your reason for asking the information. You need information. You need information. That's it. You need not give any reason. So this much, if you write, you get the marks. Okay, next. What is the procedure for commencement of conciliation proceedings under Arbitration and Conciliation Act? So conciliation proceedings, procedure you have to write. Again, it's a direct question. And how many conciliators can be there in the proceedings? Only these things you have to write. So 62.1, 62.2, 62.3, first you have to explain. That is, one second. Yeah. So that is a party should send a written invitation. So here you have to be careful in using the words. In arbitration, you are talking about or using the word like notice. Okay. In conciliation, you are telling invitation. Okay. Invitation to conciliate. Okay. Those words you have to be careful because it's a informal or amicable settlement. So you have to be careful about those words. So the party initiating shall send, first you are sending an invitation, briefly identifying the dispute. Then it says again 62.2 states that conciliation proceeding shall commence when the other party accepts. Okay, and then if the other party rejects, then there will be no conciliation. Then also it states that if the party initiating, so if there is no reply, nothing, then you have to wait for reasonable time, or if you have mentioned the stipulated time, within that if you don't get any response, then you can treat it as a rejection, but you have to send a notice. I mean, you have to send information that also. So as you did not reply, I will consider it as a rejection and conciliation proceedings will not start. So these things you have to write. The number of conciliator. So according to section 63, if you see, there shall be one conciliator unless the party agree for two or more. Where there are more than one conciliator, they ought to, as a general rule, act jointly. So one or two or three. Okay, any number of conciliator, like not like arbitration. In arbitration, you should have odd number, but in conciliation, there is nothing like that. But when you appoint more than one conciliator, it is always a rule that all the conciliators should act jointly. If conciliators only start quarreling, then what they are going to advise the people? Correct, no? So disputants. So that is why they have to act jointly. Then we will go to 5C. So 5C is divided into two. So that is, you have to answer in the light of CPC, that is Civil Procedure Code. So first one, can a case be trialable by a special judge as provided under Criminal Law Amendment 1952 be transferred to High Court? See, can a case be transferred to High Court? Right, a special judge can transfer it to High Court. So it's not possible. Okay, the answer is no. So first thing is, see, when you are having some jurisdiction, you only have to deal with it. If you is not possible, then later if you give a decision, if you refer it to High Court, that is a different issue. Or if there is an appeal, people, that is the person who is not happy with the decision will only go. But just like that, you can't transfer a case to High Court. That is one thing you have to concentrate on. Then discuss the jurisdiction of the courts depending on their power. Okay, we will see this. See, first thing what you have to see is the issue, the case of see, they have given the case law. If you remember, you can write. Otherwise, you can just write that as per the decided case law. At least like that, you can start. Okay, this is here. Antule versus Nayak and others. Okay, so this is the issue was whether a case trialable by a special judge as provided under Criminal Law Amendment 1952 could be transferred to High Court or not. Okay, it was held that court by directions cannot confer the jurisdiction to High Court of Bombay to try any case itself for which it does not possess such jurisdiction. When I myself don't have the jurisdiction, or if I have the jurisdiction, I have to deal with that case. I cannot transfer it to High Court. I can't do it. So the power to create or enlarge jurisdiction is a legislative character. See, whether High Court is having jurisdiction, I mean, whether I am having jurisdiction or whether I can transfer this case to High Court, can I give the jurisdiction to High Court? All these jurisdiction related matters are to be decided by the legislature, not by the court or a special judge. See, if I am not having the jurisdiction, if the case is complicated, I can if I'm having the jurisdiction and if the case is complicated, I can anyway refer the case. All these things is okay, but reference statement is there. But the thing is, simply can I transfer the case to High Court? Can I only create a jurisdiction and tell, please go to High Court and settle this case? It is not possible. So high jurisdiction, fixing the jurisdiction is a legislative character. Okay, nobody else can take that power. So power to confer a right of appeal or to take away the right of appeal, all these things, whatever legislature, respective act, whatever says, no, that can be done. If there is nothing in the act, then you as a special judge, you can't decide anything. Okay, Parliament alone can do it, and no court, whether you are superior or inferior, whatever, can enlarge the jurisdiction of a court or divest a person of his rights of revision and appeal. So you can't give extra, right to appeal, or you can't tell no, you can't appeal, nothing. You have to go as per the law. In law, if there is an option, like you have a, the court can decide to give grant an appeal or not to grant an appeal. Then you have the decision. You can take the decision. Otherwise, you don't have any right to confer jurisdiction upon anyone else, whether you are inferior court, superior court, doesn't matter. It is legislative in character. So these things you have to write. Thus, a court by its discretion cannot confer jurisdiction to High Court to try any case by itself, which it does not possess such jurisdiction. So when I am only not having jurisdiction, I have to tell I don't have the jurisdiction. Please, you have to take take care of the case, or maybe you, as per law, you have to approach this court. But I cannot tell, okay, I will transfer this case to High Court. Okay, they will see. That I can't do. So that is about, first question. Then about jurisdiction, you have to just say original, appellate, criminal, and appellate. All this you have to explain. Apart from that, we have also something called as territorial jurisdiction, that is regarding the place. Okay, so that you can just make a mention. So a territorial limit of jurisdiction of each court is fixed by the government, and section 6 of CPC deals with the pecuniary, that is related to money, and 9 states that the court shall have a jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. Okay, so that is about fifth question. Next, we will go to sixth one. So here again, you have two questions. That is, choice is there, internal 6 or 6A. Anything which is easy for you, you can select. So Abhinav contracts with Manoj that he will paint his house located in Azad Nagar within a month. Okay, he says, I'll paint your house within a month. And during that time, he will not take any other painting job in other premises. So during this time, I will not work for anybody else. I have accepted the contract that I'll paint your house for 1 month. And during this time, I will not work for anyone else. But Abhinav, again, after accepting, he breaches the contract. Manoj files a suit seeking decree for specific performance. Specific performance means whatever agreed, that only I want. I don't want money or compensation damage. I want the performance only. And will Manoj succeed? Also, answer making the difference between injunction and specific performance. They are asking the difference between injunction and specific performance. See again, when there is a difference, they have given it in the form of table only, if you can observe. Okay, so we will see this, what answer says. So section 14 of Specific Relief Act provides that a contract which is dependent on the personal qualification of a parties, that the court cannot enforce specific performance of its material terms, or a contract, the performance of which involves performance of a continuous duty which the court cannot supervise, cannot be specifically enforced. See, there are two things in Specific Relief Act. When you ask for specific performance, it is not that if you ask, definitely it will be granted. there are certain criteria and it is a discretion of the court. Okay, if it is a specific performance which is related to personal work, that means my personal skill is involved, then specific performance may or may not be granted. So court will not support. Or if it is related to continuous service, like daily I have to go and work, like for 1 year, 1 month, this court cannot supervise. So I will go and tell the court, today she did not come, tomorrow, yesterday she did not come. So that they can't supervise. So in these two situations, usually specific performance will not be granted. So that is the first thing you have to write. Then, in the view of the above, by keeping in mind these provisions, Manoj will not succeed in seeking a decree for specific performance of contract against Abhinav, as the contract is personal in nature. Correct, no? So it is related to it's personal in nature. And in the given situation, contract entered into between the Manoj and Abhinav have two stipulations. One is positive and one is negative. That is positive. Two stipulations are there. Correct. No, what is that? One positive is within a month I will paint the house, your house. Negative stipulation is that I will not work for anybody else. During this time, I will not work for anybody else. So here, even though positive stipulation cannot be specifically enforced, but negative can be enforced by taking an injunction. See, court will not tell you have to paint. Okay, but when you have agreed during this time, I will not work for anybody else. For that, you may take injunction. For negative stipulation, there is a chance that you can take injunction and stop him from accepting any other contract. But for positive, because it is personal in nature or continuous, anything you consider, the court may not grant specific performance. So we will see the specific performance and injunction difference. Okay, so specific performance means what? It is decreed to compel the performance. Injunction means we are preventing the violation of a negative duty. I have told I will not work for anybody else during this month. Then you can, by taking an injunction, you can stop me if I have agreed for it, if I have entered into contract with anybody else. Specific performance is doing a duty. This is more of negative in character. Then it is enforced when the act is agreed to be done. Is it performance wholly or partly of a trust? Then injunction is granted as a preventive relief. Okay, so this is a preventive relief. So preventing a party from doing something. And this is for doing something. This is preventing him from doing something. And normally, specific performance deals with contracts, and the injunction can be contract or tort, anything. Then, if a contract is of positive in its nature, it's called for a specific, and if it is negative in nature, it calls for an injunction. So, again, and there is a difference, you have to better write it in the form of a table only. Okay, then we will go to 6B. So they have given discuss with reference to with reasons following cases under Indian Evidence Act. Okay, by considering Indian Evidence Act, two situations they have given, you have to discuss that. So what is that? First one, A sells his horse to B. Okay, A sells his horse to B. B asks, is the horse sound? Is this horse sound? The question is that. A says to B, go and ask C. C knows all about it. So he did not tell yes or no. C knows everything. You go and ask him. C says horse is sound. So statement by C is confession or admission. Is it a confession or admission? The question is that, see, like I want to buy horse from you. Okay. I will come to you and ask whether that horse is sound. You will tell, I don't know, go and ask him. I will go to that third person and ask. He will tell the horse is sound. Now, on behalf of you, he is telling no, whether it is considered as a confession or an admission. So for that, first you should know what is confession and admission. So with this, information, we will try to answer. So what it says, section 17 says that an admission, what is admission? You have to tell. And what is confession? You have to tell. So it provides that an admission is a statement, oral or documentary or contained in electronic form, which suggests any inference to any fact in issue or relevant fact and which is made by any of the persons and under the circumstances mentioned in Indian Evidence Act. An admission may be made by a party or by the agent, or see who can make the admission. See, confession can be made by that person alone, but admission can be made by his agent or any predecessor in his interest, or a person who is having a joint property of pecuniary interest in the subject matter. or by a reference. Okay, so then Section 20 of the Indian Evidence Act provides that statement made by persons to whom a party to the suit has expressly referred for information is in reference to a matter in dispute or admission. So this statement is an admission according to Section 20. So what do you do? First, it's better at least one line of explanation you give for confession also. What is confession? And then you write admission, and this amounts to admission. So that Section 20. Later you explain Section 20, and then you write illustration to Section 20. A says to B, go and ask C. C knows about it, and C makes an statement is in admission. So in the view of the above, that is by applying Section 20, we can tell it as an admission. So what is that Section 20? It says that statement made by persons to whom a party to the suit has expressly referred. Correct? No, you are the party to the suit. You have only expressly referred. You have only expressly told, go and ask that person C. And C has admitted something. So this is admission only for information in reference to matter in dispute. Okay, so that is Section 20. So in the light of the above provision, it is admission. Like that you can write. Then, because they have asked whether confession or admission, better one sentence you write about confession also. That is better. Then A commits a murder of his colleague. Okay, A commits a murder in a spur of heated argument. So he did not want to murder, but in the spur of heated argument, he has committed that murder. A on reaching home confesses the offense before his wife. So he tells, see, I have killed this person. Wife is summoned by the court to testify against her husband who was in trial for allegedly committing the murder. Can A's wife act as witness? This mainly talks about privileged communication, because the communication in the course of marriage, that is between a husband and wife, happens. No, that nobody can compel them to see. If husband only says it's okay, you can go and give evidence against me, or if wife only decides yes, I will go and tell, that is fine. But nobody else, a third person, cannot compel. So that is given in Section 122 of Evidence Act only, which talks about privileged communication. So that is why it cannot be done. Court cannot compel. So in the view of the above provision, it can be said that A's wife cannot act as witness unless the person who made the communication or is representative in interest consent. So if he only consents, fine. Otherwise, she cannot be compelled to act as a witness. Okay, that is Section 122. Then 6C talks about a promissory note. So a promissory note is executed by Raja and Suraj, and a stamp is afterwards. See, after execution, they are affixing a stamp. A promissory note is executed by Raja and Suraj, and the stamp is afterwards affixed and cancelled by Raja, again signing it. Okay, signing, he is affixed and signing it. The stamping has taken place subsequent to execution. Is this according to the provisions of Stamp Act? See, first thing what you have to understand is, when you are when it comes to Stamp Act, you have to stamp either before or at the time of execution. After execution, even if you after that cancel, sign, whatever you do, it is as good as you are not complying with the provisions of Stamp Act. So this question they have asked, okay, these two people have entered into, promissory note, they have executed, but after execution, they have affixed the stamp, they have cancelled, and again they have signed. Is it valid? Is it compliance? Is it in compliance with Stamp Act? Answer is no. Okay, so we will see this. See, first thing what you have to write, Section 17 says, all instruments chargeable with a duty and executed by any person in India shall be stamped before or at the time of execution. So if the executant has already completed the execution of the document, and in the eyes of law, document could see, in the eyes of law, if the document is considered as executed, then later, after that, if you try to affix the stamp, cancel it, that is non-compliance only. Okay, so could not render the document as one stamp. So if it is done after the execution, then it is not a proper stamping. So in the case, see, one case reference they have given. If you know, you can write, otherwise also no problem. So in case Rohini versus Fernandez, so it's mentioned that where a promissory note is executed by A and B and a stamp is afterwards affixed and cancelled, again by signing it, all these things subsequent to execution, if you whatever you do, it is a non-compliance only. So in the light of the above provision and case law, it can be said that the provisions of Section 17 of Indian Stamp Act is not complied in the given situation. Okay, next we will go to 6D. Okay, so that is Arun, a husband, enters into a registered agreement with his wife Radha to pay his earnings to her. Okay, so he's entered into an agreement to pay the earnings to wife. Okay, then will to her, is it a valid contract? So the first question, first part of the question is, yes, husband and wife had entered into a contract, and husband has promised that I will share earnings with you. Is it a valid contract? Next, will the answer be different? They have changed the situation a little bit. So they are asking, will the answer be different if the husband, by a registered document, after referring to quarrels and disagreement between himself and his wife, promises to pay his wife a sum of money for her maintenance and separate residence? So is it use your answer will be same if there is a quarrel between husband and wife? If there is a quarrel between husband and wife, will your answer be same? So for that, what is the answer? So there are two questions. They have divided the question into two parts. One is husband is telling there is normal relationship. Husband is telling, entering into an agreement, and he's telling, I will give the earnings to you. That is one. If there is a quarrel and if they are living separately, then separate residence and all those things, then also will the agreement be valid? So we will see this. See, first thing what you have to write, this is as per Contract Act, Indian Contract Act. When there is no consideration, there is no contract. But there is an exception. Out of, when there is two parties who are standing in the near relation, husband and wife is near relationship only. And if they have, out of natural love and affection, if they enter into contract, and if there is no consideration also, it's fine. That contract becomes valid. So the first part of the question answer is valid, because they are husband and wife, there is no quarrel, nothing. If there is quarrel, then the answer differs. So first we will see this. Okay, it says that an agreement made without consideration is void unless it is expressed in writing and it is registered. Okay, it has to be registered under the law for the time being in force for registration of documents, and it is made out of natural love and affection between the parties standing in a near relation. So then, in this case, a registered agreement between husband and wife to pay his earnings is a valid contract. So that was decided in Punu Bibi versus Fayaz Baksh also. So it is as in writing and registered. It's writing, registered, everything. So and out of natural, general, natural love and affection. So it comes under the exceptions. So it is, even though if it is without consideration, it is valid only. However, the second situation what they have given, so that is where husband by registered document, after referring to quarrel and disagreement between himself and his wife, promised to pay his wife a sum of money for her maintenance and a separate residence, then it was held that the promise was unenforceable as there is no natural love and affection. So it's, if it is made out of natural love and affection, you can say it as an exception. But here they are quarreling and residing separately, no? Then the answer will be different. It is not valid due to want of consideration. So in accordance with the above case and provision, it can be said that an agreement which is expressed in writing and registered under the law for time being in force for the registration, and it is made out of natural love and affection, then it is valid. However, in the second situation, it is due to the quarrel and separate residence and all those things, it is not valid. It is unenforceable. So everything you have to write. You have to write about, first you have to tell no consideration, no contract. But there is an exception. What is that? Natural love and affection. In our first part of the question, it is valid because it is made out of natural love and affection. Written, registered, everything you have to write. Then the second situation is there is want of natural love and affection. It's not there. They're quarreling and they're living separately. So now this is unenforceable due to want of consideration, because that exception will not be attracted here. Okay, next we will go to the alternate question, that is 6A. Okay, 6A1. The first one is, what principle of statutory interpretation shall be applied by the courts when there is a conflict between a general and special provision? See, this is related to General Clauses Act. Okay, this or any general question also you can consider, even though you don't give any reference to any act, you can take it as in general. If there is a general provision, there is a specific provision. What is that general provision? See, for example, if there is any dispute, okay, in general, general causes act is written. If there is a dispute related to tax, okay, you have to go to court. That is a general provision. But in income tax of act, it is completely clearly mentioned that you have to go to income tax appellate tribunal. So where you will go? Special provision only will be applied and not the general one. See, for another example, assume the financial year means 1st April to 31st March. Correct? No, that is given in General Clauses Act. Assume, just see, this is not there. I'm simply telling you. For example, in any other act, Companies Act says financial year is from 1st March to maybe 28th February. But for income tax purpose or for whatever specific act purpose, that only you have to consider. You can't tell General Clauses Act says this, I'll follow that. So always when there is a general provision related to some dispute and a special provision related to some dispute, special provision will prevail. When nothing is available, go for general. When specifically for that only it is available, you have to follow that only. That is a general question. Okay. So the court shall apply the rule of construction that general provisions yield to. So you can give this answer in light of, General Clauses Act, or you can give the answer in relation to interpretation of statutes. Everything is acceptable, but always when there is a general and special, always you have to give importance to special provision only. So whenever it is possible to do so, the construe provisions which appear to conflict. See, always when there is a conflict between one and other provision, you have to harmonize construction. But if it is not possible only, then give importance to special and not the general one. So this is also expressed in Latin maxim, that is generally a specialibus non derogant. That is a rule of implied exception. It means general things do not derogate from special things. Things general do not restrict or detract from special. So universal things do not detract. So something if I tell, we follow this only we will do. But at your home, at your house, in your family, if you follow something else, you have to do that only. You can't tell generally people are following this. No, this is what we are following. That's what you have to follow. It's like that. So this is a well-known proposition of law which says when a matter falls under any specific provision, then it must be governed by that provision only and not by general one. So the general provision must admit to the specific provisions of. Okay, next one. 6A2. That is no law. Question says no law can clothe administrative action with a complete finality, even if the law says so. That means no law can give 100% right or power to administrative officials. Whatever he says, Commissioner of Police says that itself is final. No, that cannot be done. Even if any law says so, for the courts will always examine the ambit and even the mode of the exercise of that power to check the conformity with the fundamental rights. So courts, whatever law says, court will check whether that administrative authority has used his power properly or he has misused. So in the light of this sentence or the statement, discuss judicial review at the stage of exercise of administrative discretion. So this is easy. Okay, at the stage of administrative discretion, what is a judicial review? So there it is divided into two. That is, authority has not exercised the discretion properly. That is abuse of discretion. And next one is authority is deemed not to have exercised the discretion at all. That is non-application of mind. Simply whatever the government says, that you keep on following. So that two things. So abuse of discretion, you have to write everything. Okay, mala fide, irrelevant consideration, leaving out the relevant consideration, arbitrary order, improper use, improper purpose, colorable legislation, then non-compliance with the proper procedures and principles of natural justice. That is, you don't listen to both the parties. Simply one person, you listen whatever he says and listen to him and give the decision. And exceeding jurisdiction. So these things is misusing your powers. Then non-application of mind is just government says you follow. If they say yes, you also say yes. See, you have the power and you have brains. You have to use it. No, that is why for you to use only this power is given. You can't simply, mechanically you can't act. So non-application of mind comes under that. It comes like acting under dictation or self-restriction or acting mechanically. See, you are not considering anything. Simply mechanically, whatever is written, exactly you apply and give the decision. So these things you should not do. This comes under judicial review at the stage of exercise of administrative discretion. This as it is, you have to explain. Then comes validity. This is validity of custom, direct question. A custom will be valid and will have binding force only if it fulfills certain conditions, essential condition. What are they? It's just this: time immemorial, certainty, reasonableness, compulsory observance, conformity with law and public morality, then unanimity of opinion, peaceable enjoyment, and consistency. So everything you have to, it's just the direct question, you have to explain that. But always may do this, write a subheading and then start writing the explanation directly. Custom must be certain, don't write like that, because you should attract the person who is correcting the paper, that you have to write certainty. Underline, if there is time, underline it, so that you are immediately, his attention goes there, and he looks into these points, certainty, reasonableness, then only he'll feel like giving you marks. Okay, don't just write explanation. Wherever possible, give the subheadings. Then last question, that is in civil suits, sometimes court allows the defendants to claim set off. This is about set off in CPC. Okay, against the plaintiff demanded by a certain sum of money legally recoverable by him. In the light of the statement, discuss whether in India distinction between legal and equitable set off is given. See, first you have to explain about the set off. What is set off? Set off means what? I have filed a case against you that I have to receive money. Okay, and then you also have to receive some money from me. So you have to set off. The only balance will be payable. So you are claiming that. So there is something which is called as legal set off and equitable set off. In legal set off, the transaction can be two different transactions. Like for example, I have to you have taken loan from me. I have taken some furniture from you. Two different transactions can be set off. In equitable set off, it should be related to the same transaction. In legal set off, it will be ascertained sum of money. We know exactly how much you have to receive. I've given you 1 lakh rupees loan. You have given me 10,000 rupees furniture. So 90,000 only is payable. That ascertained sum of money. In equitable set off, you just know that you have to claim set off, but you don't know by how much. For example, I am your employer. I have not given you 3 months salary. Reason is you have broken the furniture in my office, or maybe you have destroyed a laptop or some office important files you have deleted. So I don't know, to claim the set off, I don't know. So that is why I have not given you salary. But amount, if you ask, I don't know. I don't have a certain sum of money. You file a case against me that I have not paid you salary. Now I will claim equitable set off. So this difference you have to write, even though in the guideline answer, they have not given in the form of a table. Please, you write it in the form of a table. Okay, equitable, what is legal, what is equitable. So these differences, 3-4 differences you write, and you'll get marks. So first you tell one sentence, what is set off, and then you can tell the difference. Yes, in India, legal is different, equitable is different. And then you start explaining the differences. So with this, we will complete today's session of analysis of December 2023 JIGL paper for new syllabus. And I wish each one of you all the very best for your exams. Thank you so much.